Check 1, 2.
Check 3, 4. Check 3, 4. Check.
Check.
Okay, Bev, can you hear that? Testing, 1, 2. Coming through okay? Okay. Okay. I thought so. use this. I don't remember using this since, you know, I'm here.
Yeah, I'm really not the guy to ask. No, that does seem right, it was up there, but.
Yeah, it does kind of.
Wow, it was pre, yeah, because that was for the WebEx audio, and before that, for the, long distance, all the companies.
Well, just set it right here for now. It'll be okay.
I assume.
Maybe that, I better check.
Well, I know it hasn't sat here, but maybe, I don't know that.
You know, Commissioner. Mystery solved.
Yeah, that's correct as far as I know.
Okay.
We'll be going down first.
Awesome. Thank you.
Do you need a formal answer?
No.
No. Yeah, Marisol, how are you? Good. Well, I saw you on the internet.
Sometimes I down there.
Oh, they're coming out here. They're down in the, yeah. There's a small area back through here. They don't use it too much. How you doing?
How are you?
Not yet, I'd like to do something. Now we go skiing at Christmas.
Yeah, I've heard.
We do skiers at Christmas.
Check one.
Did they cancel? Did they? I figured that's what it must have been. Yeah, because it seemed like it was expedited. I didn't think, it was my husband, whether it be a bad on
Check one.
Tuesday would have been.
Good morning, everyone. This is Judge Hatcher. This is the Public Service Commission. We are here on a Tuesday at 10 a.m. This is January 30th, 2024. Let's go on the record. I'll restate the date for the record. It is January 30th, 2024. This is file number EO-2024-0002. This is the evidentiary hearing in front of the Missouri Public Service Commission regarding Evergy's customer data. Let's go ahead and get introductions of counsel going for Evergy.
Thank you, Judge. On behalf of Evergy, let the record reflect the appearance of Roger Steiner and James Fisher. Our contact information is in the file.
Thank you. And for MECG.
Good morning, Your Honor. Tim Opitz on behalf of the Midwest Energy Consumers Group, or MECG.
Thank you. I'm going in the order of opening statements, just to help me remember that order, for Office of Public Counsel.
Good morning, Your Honor. John Kleiser and Anna Martin on behalf of the Missouri Office of Public Counsel.
And staff.
Carolyn Kerr and Whitney Skurlock on behalf of Missouri Public Service Commission.
Thank you. Quick reminder, please mute your phones. Also, if you are on WebEx, either on phone or via computer, please go ahead and mute yourself. If you're on a phone, that is *6 to mute and unmute yourself. Let's get into some preliminary matters. I have a list of 5 very quick things. Office of Public Counsel, you had an objection. You had a filing regarding confidentiality. Evergy responded with a filing. Does that take care of your concern?
I believe so. I did, because the numbers were no longer confidential, I didn't know if we would have to do anything regarding going in camera or anything. We do not, correct?
I'm going to wait on your second question. Do you have any objections? Do you still want to pursue your confidentiality objection that you filed?
If the information is public, then, okay.
They responded. I just need a yes or no. And I don't mean to push you on this, but it's just a filing.
One moment. So, their numbers were public. I don't know if we should be treating them as confidential or not, but.
They said the numbers are public.
No, they filed them publicly, so.
We're good.
Okay. I apologize. I believe we are okay.
Excellent. Exhibits. My normal announcement about exhibits. This particular judge, will take responsibility for the pre-filed exhibits. I appreciate the printouts that were brought. For any other parties, no need to produce any paper copies of pre-filed exhibits. My method of taking care of any errors that parties want to correct in testimony is typically in a errata sheet with its own exhibit number, just to make it easier for the record and easier for everyone to cross-reference. We don't have any late filed exhibit requests yet. The deadline I typically file for that is a week or 2 after our hearing conclusion. I also, since we're on exhibits, I want to make sure that I acknowledge in past cases I've gotten requests to have the exhibits, both a list and the physical exhibits, entered into EFIS soon. I endeavor to meet that challenge with this case. I have traditionally produced a notice of exhibits admitted within a couple days of the hearing conclusion. That will happen again. This case, I am going to make all reasonable efforts to get the actual physical exhibits into EFIS, and that will be before the transcripts, which is typically when I wait to file those exhibits. Any other issues or questions on exhibits? Excellent. I would just like to throw this out there. I do not expect an answer, but in testimony, in our discovery conference, and in the parties' various pleadings, we have referred to the requests for customer data sometimes as data requests. I'm not here to pick a name that we want to call whatever the customer data requests are. I just want to point out that we will be clarifying that in any report and order that comes out, that a data request is one thing and this is not it. Okay? Two last things. Staff's motion to strike. You had a motion filed on last Friday for 2 witnesses. Do you still want to proceed with that motion?
Yes.
Evergy has responded to their motion. The objection to testimony of witness Lutz was a couple lines, and the testimony was arguably rhetorical. As I recall, it asked a question and then sought some commission advice. The commission can take that testimony for what it's worth, and it will deny staff's motion to strike those couple sentences. The second objection was to the entire testimony of Sean Riley. His direct testimony as that it was not related to the purpose of the stipulated docket. Evergy responded that it was, in fact, related to the purposes of the docket in explaining how all this information worked in conjunction with each piece. The commission is not persuaded by staff's arguments to strike the testimony of Sean Riley. Staff's motion is denied. Opening statements, my last announcement. Does anyone have any statements, opening statements that they expect without commissioner questions to go over 45 minutes? It's a serious question. No, no. Excellent. Let's get to opening statements then. Evergy, go ahead. Oh, and I would like to state for the record, we have in attendance Chairman Scott Roop, R-U-P-P. We have in attendance Commissioner Hahn, H-A-H-N. On the WebEx, we also have Commissioner Kolkmeyer, K-O-L-K-M-E-Y-E-R. Mr. Fisher, the floor is yours. Thank you.
Thank you very much, Judge. Let me see if my little PowerPoint is going to work. Okay. Yep, looks like it'll work. Thank you very much, Brian. May it please the commission, my name is Jim Fisher, and Roger Steiner and I will be representing Evergy, Missouri Metro and Evergy, Missouri West today, and what's a very unique proceeding, I think. This proceeding emanates from Evergy's 2022 rate case. In that case, staff witness Sarah Lange filed testimony requesting that the commission order Evergy to produce a massive amount of data which she apparently wanted to use for future rate design issues. The company offered rebuttal testimony challenging that position and that need. The long list of data that Ms. Lange requested the company produce is listed in her testimony in the last rate case, and it's also listed in the direct testimony of Brad Lutz, in this case, pages 3 through 5, and I believe it's also now part of our joint statement of facts. It has a stipulation attached to it. I'm going to discuss in a moment the type of data that's being requested by Ms. Lange. But before we do that, let's look at that stipulation that was part of the rate case. In order to resolve this issue in the last rate case, Evergy staff and other parties agreed to the following. Prior to July 1, 2023, the company will identify and produce data requested in the direct testimony of Sarah Lange. If the requested data is not available or cost prohibitive to produce, the company will file a motion to establish an EO docket. In that docket, the company will provide the reason why it cannot provide the requested data and its individual estimate of the cost to provide each set of requested data for the further consideration of the parties in the commission. This stipulation was approved by the commission, and then on June 30th, 2023, Evergy filed a motion to establish this case when the company determined that the data that was not available and would be cost prohibitive to create and produce. The purpose of that motion was to request the opening of the EEO docket, as Evergy agreed to do in the rate case stipulation, so that Evergy could provide in detail the reasons why the requested data is not available and the cost prohibitive nature of it to produce. The commission granted the motion and opened the case, and so here we are. On November 1st, 2023, Evergy filed the testimony of Brad Lutz and Julie Dragoo, which explained in detail the reasons why this data is not available and provided estimates of the costs of producing the data. I believe the commission's very familiar with Brad Lutz since he's been involved in rate design cases involving Evergy companies and their predecessor companies for about 20 years now. Julie Dragoo is the Senior Director of Strategy and Support for Evergy. She explains the company's systems, detailing the data relationships and providing further support for the cost estimates detailed in Mr. Lutz's testimony. She has responsibility for many of the company's systems related to these data retention requests. Evergy also filed the testimony of Mr. Sean Riley, a partner with PricewaterhouseCoopers LLP. As an expert in utility accounting, he offers insights into industry practices and confirmation that Evergy is following normal practice with its systems and data management. He also offers reactions to select staff data retention requests, and more specifically, Mr. Riley testifies that the regulated utilities have evolved in a consistent manner as a result of shared best practices regarding the use of technology, systems, processes, and controls for the purpose of operating as efficiently, reliably, and effectively as possible for the benefit of all the utility stakeholders. Mr. Riley testifies that the company's use of a billing system and an accounting asset tracking system as core systems, fed by and linked with metering systems, work management systems, and even data warehouse systems are quite typical in the industry. He also points out that the uniform system of accounts requires consistency so that regulators can determine reasonable cost-based revenue requirements, ensuring consistency between utilities. And that Evergy's responses to the data availability and deliverability in this case are reasonable based upon what Mr. Riley has observed across the country. But perhaps most importantly, Mr. Riley testifies that based on his experience working with utilities.
Are you listening to a hearing or something?
The evidentiary hearing is going on.
I would like to remind our online listeners to please mute your phone. That's *6 if you're on a phone, or on the computer there should be a mute button down at the bottom of your screen. My apologies, Mr. Fisher, go ahead.
Oh, not a problem. Thank you, Judge. As I was saying, perhaps most importantly, Mr. Riley testifies that based upon his experience working with utilities across the United States, he's not aware of distribution cost data existing in a format requested by staff that could be provided to immediately satisfy staff's requests for cost by rate code. I'd encourage you very much to ask Mr. Riley questions about his experience with regard to other utility systems across the country and the industry's ability to deliver the kind of granular data that's being requested by Ms. Lange in this case. Okay, well, let's go to the issues. The company is seeking a focused consideration of the data requested by staff and the Commission's direction on how rate design should be supported on a going forward basis. Now, from Evergy's perspective, there are 4 primary issues to be decided in the case, and the first one is, should the Commission order Evergy to create and produce the data requested by staff? The second is, what is the expected cost of creation and production of the data requested by staff? The third issue is, should the commission order the deferral of all costs associated with the creation and production of data for the possible recovery in a future rate case? And should the commission, the fourth one would be, should the commission provide guidance concerning rate design proposal development and the company's obligation to support the data needs of staff when the data needs are beyond the needs of the company and not associated with the company's proposals? Now, before I address those specific issues, I'd like to explain a little bit of background about the case. It's important to note that much of the data requested by staff in this proceeding appears to be designed, at least in part, to support their long-term vision of electric rate design for the future. However, the commission has not adopted the staff's long-term vision for electric rate design for Evergy, and as far as I know, the commission has not adopted that as a policy for the state of Missouri. Nevertheless, staff is requesting that the company expend large sums of money, devote many man-hours of effort, and utilize a large amount of information technology resources to provide data to support their long-term view for rate design. Evergy respectfully suggests that it's inappropriate for the commission to require the creation and production of the data requested by staff in this case, since the commission has not determined that this enormous effort is required or cost beneficial for future rate cases or electric rate design cases. Now, on the topic of rate modernization, since the conclusion of the last rate case, the company and staff have had 2 meetings to explore this topic, and the company has participated in the initial non-residential rate design workshops held by Ameren, resulting from Ameren's rate cases, file numbers ER 2021-0240 and ER 2022-0337. Regarding the meetings between Evergy and staff, these resulted from the company's most recent rate cases and included Mr. Opitz as a representative of the industrial customers. Staff witness Lange provided a detailed walkthrough of her vision of the residential and non-residential plan for company's consideration. The details shared by staff have been considered within the proposals being finalized for the upcoming Evergy West rate case, which we expect to be filing shortly. At this point, it's expected that the proposals will be made by the company to adjust non-residential customer charges and facility charges. It's expected that testimony will be offered concerning reactive demand, on-peak demand charges, and the hours use energy charge structures. But Evergy will not suggest material changes to the existing rate structure. And to be clear, the company will not be supporting the adoption of voltage and infrastructure-specific customer and facility charges without regard to class. It's expected that these proposals will be fully examined in a future rate case, and additional views may be offered by other intervening parties, particularly representatives of industrial customers. The company therefore recommends that the commission decline to order sweeping changes in this case to the company's computer systems and accounting systems. But simply put, it's inappropriate to require the creation and production of the data requested by staff, since the commission has not endorsed and approved staff's long-term plan for electric rate design in Missouri, especially at the substantial cost that would be required to create and produce such data. Evergy does not believe that the creation and production of the data requested by staff will be required to process the upcoming Evergy West rate case or other rate cases in the future. Certainly, the commission has processed dozens of electric rate cases and electric rate design cases without the need for this type of granular data, and the expansion of the time of use rates does not mandate this radical change of approach for Evergy and its customers. Okay, regarding the second issue, estimates of the cost of creating and producing the data requested by staff. That is contained in the exhibit attached to Mr. Lutz's direct testimony It's also attached to Evergy's position statement. And the direct testimony of Mr. Lutz in Evergy's position statement discusses the 10 sets of data, I'll call them sets of data here, Judge, that were originally identified in Ms. Lange's testimony in the last rate case. The cost information was initially classified as confidential, since it would be quite useful to vendors in the future that might be bidding on projects to modify the company's systems to create and produce the data requested by the commission staff. But for the convenience of the commission and the parties to this case, Evergy has declassified that cost information to make it easier to discuss it in this case without going in camera. The information on the next two slides summarizes the cost to create and produce the information in each of the individual sets of data. We've said they're data requests, Judge, but what we're talking about are the sets of data that were originally in Sarah Lange's testimony in the rate case, and now we've talked about it in that way in this case. The costs associated with the first 5 sets of data are summarized on this particular slide. The first set is by far the most costly and deals with distribution system data by rate code and by voltage level. Evergy has estimated that it would take $5 to $10 million for the design phase and another $75 to $100 million for the implementation phase to create and produce the information requested by Ms. Lange in the first set of data. The second set of data is estimated to require 140 hours of labor and $21,000 to complete, plus ongoing maintenance. The third set of data is estimated to require the same level of effort as the second set of data. The fourth set of data is estimated to require 360 hours of labor and $54,000 to complete, plus ongoing maintenance. Data request number 5, or the fifth set of data, is somewhat more difficult to specify, but Evergy has estimated the design phase would cost $1 million to $10 million, and the implementation phase would cost a minimum of $2.75 million to $20 million. Now, Julie Dragoo can explain why there's a range of estimates on DR5, and I think that would be a topic worth inquiring with her about. The next slide, I've addressed the estimates for the remaining DRs. I won't go through all those DR requests in this brief opening statement, but I would like to highlight a few of staff's requests for data at a high level. I think I'd like to focus first on the first set of data, since this data request is the most problematic for the company and the most expensive for consumers. This set of data appears to address cost allocation data for distribution plant. And let me just go to that one. The first set of data asks that we identify and provide the data required to determine transformer costs and expenses by rate code, primary distribution costs and expenses by voltage, secondary distribution costs and expenses by voltage, primary voltage service drops, costs and expenses, line extension costs, expenses, and contributions by rate code and voltage, and meter costs by voltage and rate code. This first set of data is perhaps the most problematic in this case, and it's by far the most expensive to create and produce. Neither capital investments nor maintenance expenses are currently tracked by voltage class or by rate code, and that's a critical point. Evergy's computer systems and accounting processes are not capable of creating and producing the requested data by voltage level or by rate code unless we spend multi-million dollars worth of, which is 80 to $100 million is what the estimate is, and that's about 10 times what was spent to implement the Commission's order on time of use rates in the last rate case. Evergy estimates the cost of complying with this first set of data is $5 to $10 million for the design phase and another $75 to $100 million for the implementation phase. Operationally, many of these facilities are shared by customers on different rates and receiving service at different voltages. Certainly, our distribution system is a shared system, and some customers are on different rate plans and they're on different voltages. And I think that's a critical point, and I'd encourage you again to ask Julie or Brad about that issue particularly. Data request number 8C1 is also related to the first data request, since it requests that this same information be provided to staff upon request. In other words, anytime staff wants to request it, Evergy would have to go through the time and expense to create and produce it. We don't think this is a reasonable approach. Upon request of staff is a very open-ended requirement, especially after seeing the unbridled approach to discovery that the staff took in this case. At this time, the Commission should reject the staff's recommendation to change the cost accounting approach for distribution infrastructure and related data requests. And that would be particularly data request 1 and 8C1. It's simply not cost-effective to change the company's computer and accounting processes to accommodate this granular approach to create and develop data by rate code and by voltage level, merely to change the way we have historically allocated distribution plan. Now, based upon what I read in the staff's position statement, I believe even staff may finally be agreeing that it would be imprudent to spend $180 to $100 million on this particular request. Data request number 9 and 10 are also problematic. Data request 9 states, develop the determinants for assessment for assessment of an on-peak demand charge to replace the current monthly billing demand charge, and for potential implementation for customers not currently subject to a demand charge. Data request 10 asks Evergy to begin to retain and study data related to reactive demand requirements for each rate code, which would include residential, I think, and sample customers within each rate code. The Commission should reject data requests 9 and 10. Deployment of an on-peak demand charge or changes to reactive demand charges have not been ordered for the company by the Commission, nor explored in any detail as a part of a recent rate case for the company. Configuration would be needed to create reporting for the collection of hourly KW during any peak period identified as data request number 9 would require. This request is not practical or needed. More extreme changes would be needed to obtain what's known as KVAR data for the reactive demand data request if the data is expected beyond those rates that are included in the reactive demand charges today. As explained by Mr. Lutz's schedule, billing determinants are being retained for rates for reactive demand, where that's a component of the rate, and staff's requests for data request number 9 and 10 are just not necessary. Let's go to the remaining data requests. We would request that the Commission provide guidance concerning each of the remaining data requests. As explained in the direct testimony of Julie Dragoo, Evergy recommends the Commission reject as unreasonable data requests 5 and 6 to assess the subparts of data request number 8 as separate requests, and to reject as unreasonable the subparts to the data requests that are impacted by DR 1 and 5. And I'd ask that you ask her questions about that recommendation because it is fairly technical. For the other data requests, it's important for the Commission to understand Evergy's position with regard to the data requests and to acknowledge the level of costs associated with providing the new and different levels of data. The company is certainly willing to work with the staff to further develop requirements that would refine the cost estimates and timing for the other data requests. But a major part of those conversations needs to be to align staff's expectations on the format and the frequency of sharing that data. Now, the data requests that we're asking for specific guidance on are listed at the bottom: 2, 3, 4, 7, 8A, 8B, HC2, HC3, HC4, and HC5. If the commission decides to order the development of any of this granular data demanded by staff or requested by staff, it must provide the company with a means for recovering the cost of complying with that order. In conclusion, let me address the last major issue. The commission should provide guidance to the company and the staff on the company's obligation to support the data needs of staff when the data needs are beyond the needs of the company and not associated with the company's proposals. This data support represents incremental work for the company, often performed in place of the company's operational work. Staff is seeking, in this case, comprehensive access to customer data, possibly made available at all times and at a level of detail beyond the company's need for purposes of supporting their own independent recommendations for rate design. The company is seeking to have the company create data and do analysis merely so staff can develop its own rate design proposals, which may not be supported by the company or consistent with any industry practices. They're seeking data access outside of a general rate case in the name of reducing regulatory lag. They're not seeking to affirm the company's rate design proposals, but instead to pursue rate design plans in spite of the company's recommendations. The data requests by staff to support these independent proposals have grown considerably and have moved beyond the data granularity and frequency the company maintains for its own operational and rate-making purposes. And as a result, these requests would compel the company to devote incremental efforts, taxing a wide cross-section of corporate resources to be able to provide the information they're requesting. Evergy does not believe the staff's approach is reasonable or appropriate. Now, relatively recently, staff has begun to offer rate design recommendations in general rate proceedings that are based solely on their views and are offered as an alternative to the company's rate design recommendations. Prior to that time, staff rate design recommendations had consisted of proposed variations of the company's rate design proposals. And that approach allowed for manageable rate design outcomes. However, under the newer staff approach, both the company and staff expend considerable effort to develop and support their respective proposals. Then the commission has to choose between them, or in the case of the last company's rate case, issue an order implementing a different or hybrid design. Now, under the competing proposal approach, staff is blurring the lines between oversight and management. And I think this puts the commission in an increasingly difficult position. Now, from the company's perspective, the staff has a different role from the company. Consistent with case law, the company manages the business and the staff aids the commission in providing its regulatory oversight provided by statute. The commission in turn regulates the company to ensure the customers receive safe and adequate utility services at just and reasonable rates. In exercising this regulation, the commission may set policy or expectations for the company to meet. And under these roles, it's not necessary that staff have symmetric access to the company's information systems. And the staff should not be dictating, especially over the objections of the company, the rate design that is being offered by the company to its customers. Staff should not be dictating to the company how it manages its business and what analysis is required to do, irrespective of the cost of the analysis or the cost to create new data. Therefore, the company should not be required to expend significant sums to support a staff proposed rate design, which may be radically different from the status quo and which the commission hasn't approved. With that, I will take your questions. I'm happy to direct your questions to the appropriate expert, who's probably the one that's going to answer it. But if you have questions, let me know.
Thank you, Mr. Fisher. Are there any commissioner questions for Mr. Fisher? Hearing none, Thank you, sir.
thank you
I'd
very
like to
much.
invite Mr. Opitz if he has an opening statement. And while he is on his way, I'd also like to announce for the record and for our listening and in-person audience, the presence of all 5 commissioners now. We have been joined by Commissioner Maida Coleman, M-A-I-D-A, Coleman, C-O-L-E-M-A-N, and Commissioner Jason Holzman, H-O-L-S-M-A-N. Mr. Opitz, the floor is yours. Go ahead.
May it please the commission, my name is Tim Opitz on behalf of the Midwest Energy Consumers Group, or MECG. MECG was a signatory to the stipulation that is at the core of this case. We intervene. We have a concern about the cost of complying and whether the company has in fact complied with what it agreed to do. I just want to mention a few points, and I won't take up too much time, but the first is to reiterate our concern about the cost estimates that the company has put forward, and whether there is a need to incur that cost, whether there is any benefit to incur that cost, and whether there is any desire from customers to incur that cost. It's MECG's view that none of those criteria have been satisfied in this case, and so it would be unreasonable to require the company to incur those costs. The second point I want to make is that the company is asking if it is ordered to incur these costs to compile and update its systems and incur these many millions of dollars of expense to, in effect, get a regulatory asset to defer that cost to a future rate case. I would urge the commission, if it does choose to order this data compilation, to not order a regulatory asset, at least not at this time. Missouri Commission practice has established when deferral is necessary. The courts have upheld that. I don't think we have enough information to show that that's been met, especially given that there is a rate case I expect any day that's been noticed, so any cost incurred may or may not incur within a test year period. And then the last point I want to address is essentially the last point that the company made about getting guidance from the commission. While I am always supportive of hearing the commission's thoughts, and in many cases MECG takes that back and considers your criticisms or your concerns in adjusting our positions in subsequent cases, I'm not able to fully endorse what I think the company is suggesting to say it's inappropriate for staff to be doing this at all. MECG has its own allocation and rate design differences with what staff is doing, but in this particular case, our concern is about the cost that would ultimately be incurred, whether there's any benefit to incurring that, and whether the company has complied with its agreements. So I would ask you to avoid issuing any broad mandates prohibiting staff from looking at these sorts of things in the future. But I would just say in conclusion, I think what you need to do here is find that the company complied with its agreement. Don't order them to incur these costs. And if you do order them to incur any portion of these costs, don't establish a regulatory asset for that, at least not in this case. That's all I have to add.
Thank you. Are there any commissioner questions for Mr. Opitz? Hearing none, thank you, sir.
Thank you.
That will bring us to the Office of the Public Counsel. And Mr. Kleiser, the floor is yours.
Thank you. If it would please the commission. So what is this case about? To answer the question simply, this case is about whether or not your staff will be given access to information that it believes is necessary to fulfill its duty. Stated another way, this case is an opportunity for this commission to help prepare its staff to provide the commission with the fact-based recommendations that the commission should expect from its staff in cases moving forward. What this case is not about are the false claims that Evergy has made, both in its position statement and its opening. And specifically, this case is not about an attempt by the commission staff to leverage an undisclosed long-term vision of electric rate design, nor does this case represent a blurring of the lines between regulatory oversight and company management. And while I would prefer to address what this case is about instead of those, I feel it's necessary to at least address those issues because they were brought up recently in Evergy's opening. So let's start with the idea that staff is invading the province of company management. If there is exactly one thing that this commission is actually tasked with doing, it is fixing the rates to be charged for utility services. Now, when we talk about fixing rates, that incorporates three ideas. First, it's coming up with the revenue requirement, which is how much the company is allowed to earn over a given year. And then second, you have to divvy up that revenue requirement among the different classes. We call that cost allocation. And then the third one is the rate design element, which is figuring out how to design the actual rate to allow each individual class to recover its allocated portion of the revenue requirement. Now, the issues in this case predominantly focus on that second idea, the concept of cost allocation. And it needs to be clear that cost allocation is something that is addressed in every case that comes up before the commission. In fact, we've had cases where the only issue in front of the commission was cost allocation. It's somewhat ironic that the representative from MECG just mentioned this, but I don't know if you recall, a little while back we had an Ameren case where literally the only issue in front of the commission was whether or not you should have one of two competing cost allocation methodologies, and the company really didn't have a stake in that fight. It was really just staff, OPC, and MECG fighting. So this idea that you can have, it's company versus staff when it comes to that, that's not true. Staff needs to be able to put forward a recommendation on cost allocation and rate design because sometimes it's interveners who are the ones challenging the positions, not necessarily the company. And again, staff is always opined.
Could you slow down a bit?
I will do my best.
Thank you.
Apologies. So that brings us to the second point. Contrary to what Evergy would have you believe, this is not something new, right? This is not staff coming up with something whole cloth that they've never put before the commission. It's actually the exact opposite. If you can go back more than 5 years to staff's rather lengthy report on distributed energy resources, filed in April 2018 in case EW 2017-0245, and find the genesis of staff's data requests in this case. And the commission, I should point out, issued an order in that case that staff's recommendations, quote, promoted good public policy. So given the history, staff has been nothing but upfront and clear with both the commission and Evergy about its approach to rate design and its attempts to integrate existing practices with the advancement of new technology and ideas. And that, I think, brings us to the heart of the matter. This case exists because your staff, your independent, loyal to no one but you staff, is saying it needs this information to do its job. And they are saying that because the information they have relied upon in the past has either become outdated or will no longer work with the more recent changes to how utility rates are regulated. As of right now, the lack of data that staff is seeking is making it substantially harder to perform weather normalization, get billing determinants, or properly gauge the appropriate throughput disincentive for Evergy's MIA, and that is the Missouri Energy Efficiency Investment Act for the reporter. These problems are explained in the testimony of staff witness Kim Cox, Jay Lubert, and Michael Stallman. However, the problems do not end there. Moving forward, this lack of information is also going to make it very difficult to implement things like distributed energy resources, or DERs, which I'll refer to as DERs. And as a reminder to the commission, DERs are small-scale energy resources usually situated near the site of electric use, like rooftop solar, combined heat and power, or battery storage. It is still a somewhat evolving, somewhat new, but still quickly developing issue in rate making across the United States. More importantly, the information that staff is trying to elicit here will become increasingly vital moving forward when it comes to properly setting rates for customers who make use of DERs. So, resolving this case in favor of staff will therefore serve to benefit not only the existing programs and rates, but will also help develop proper pricing for new and emerging technologies. Another point that I want to ask the commission to consider is to stop and really think about who is making this request and why. Again, this is your staff asking for information, right? It's not like staff suddenly woke up one day and said to itself, I think I'm going to go massively increase my workload for no reason. They have a good reason for asking for this. They legitimately believe that this information is necessary to do what you expect them to do. And I can't think of any reason why you would doubt that thought. Moreover, your staff has been eminently reasonable and patient with both its request and its method for obtaining this information. As was mentioned, they settled the last rate case so they wouldn't have to bring this issue in front of you. They tried their best to work with the company to get to an agreement that could work, to get the information in a way that was cost-effective and made sense. They've been out near more than 500 days since that agreement, trying to figure out a way to make this work. So it should be clear that your staff has taken every effort to reach a workable solution. And I also want to stress that your staff has had some better degree of success with other utilities. They've managed to work somewhat with Ameren and Empire to get closer to getting the information that they feel like they need, which just reinforces how reasonable this information actually is. Instead, the commission needs to recognize what's truly unreasonable in this case is Evergy's cost estimates for what it thinks it's going to cost these to get this information. And to be frank, Evergy, in our opinion, simply hasn't put forward a good faith effort in trying to come up with how much these things are going to cost. And I say that primarily because the company has not provided any testimony to explain how it developed these numbers in a satisfactory way. For example, the OPC sent a data request to the company that basically said, hey, can we get an itemized list that breaks down this, $100 million or these various man hours? And the company's response was basically, no, that's not possible. We didn't come up with those requests in a way that allows them to be itemized. So this all leaves us in a mess, right? And that's why we're here. That's why we're having this hearing. How do we get out of this mess? What is our escape route from this quagmire? The simple answer is the one that I think I interpret from the testimony of Ms. Lange on staff, is that the commission should keep this docket open in order to allow the parties to work towards a solution. I think it's telling, that no party as of yet has actually put forward that they should be making those investments. I think that the end goal here from all parties is to try and work to a way with getting this information that doesn't require making that $100 million investments, and I'm sure staff will correct me if I'm wrong on that front. So what would that do? Well, it requires Evergy to provide the information that it says it can at a reasonable cost. And I think you'll agree that if you looked at that thing, there were a couple that were $20,000, a couple that were $50,000. Okay, that's reasonable for this kind of company. And then for the others, the really big ones, we just need to work together to try and find a solution that will allow this information or something similar to this information to come in without needing to make those $100 million investments. And to do that, you need to keep this docket open and keep the parties working on it. But what happens if the commission says no to staff? What happens if you just shut down staff at this end? Well, again, the future programs that the commission might be interested in, such as distributed energy resources, will become significantly more difficult to price correctly. Moreover, any data on important topics like rate switching between available rate options and the impact individual rate classes have on the company's revenue requirement are going to become more unreliable, more difficult to determine. For all these reasons, I urge the commission to listen to and support its staff as they do their best to do their duty to this commission. And as one final point, I will touch very briefly on why the OPC is here. The simple answer is that we believe that a strong, independent staff is an asset to this commission, to customers, and quite frankly, to the company itself. And so we decided to support staff. The OPC has provided its own witness, Dr. Jeff Mark, who's had years of experience in regulation and can help provide additional background to this case, the relative positions of the parties, and the importance this information has moving forward. And I strongly encourage the commission to ask Dr. Mark any questions that you might have, and explicitly ask the commission to ask Dr. Mark any of the same questions that you would pose to staff or company witnesses. And that will be my close. So with that, I'll ask if there are any questions.
Thank you. Chairman Roop, go ahead.
Appreciate it, Mr. Kleiser. You made comment that Ameren and Empire has worked with staff so that they would have access to better data, or however you might have phrased that. Can you expand on that, please?
Unfortunately, I cannot. That is a question that I would pose to the company directly if you want more information. And I'll be clear, my understanding is that they are in the process of discussions, so I don't know how much of that will be covered by confidentiality, but my understanding is that they are working.
Commissioner Hahn? Sorry.
Thank you, Mr. Kleiser. You mentioned that the docket as presented by staff witness Lange in her testimony should remain open to try to work through the cost prohibitive data. But from my understanding of reading the testimony of the Evergy witnesses is that the data can't be produced, the cost prohibitive data, because the systems don't actually work together. So if a system has to be created to merge the data, then that does have a cost. What would OPC's position be then?
I want to make sure I understand your question correctly. Is it saying that if it truly is the only way that we could spend $100 million was to get this information, what should we do at that point?
Yes.
Honestly, I'm going to have to defer that to my expert. I'm not entirely sure what our position would be on that, so I would need to think more on it. My personal belief is that I think that there is some way that we could achieve some kind of workable solution that would be beneficial to both, not both, but all parties. So call me an optimist if you will, but I'm holding out hope.
Thank you, Mr. Kleiser. Ms. Kerr for opening statements. The floor is yours. Go ahead.
Thank you. May it please the Commission. My name is Carolyn Kerr, and I'm an attorney with the Staff Counsel's Office of the Missouri Public Service Commission. We're here today because back in August of 2022, Evergy Missouri Metro and Evergy Missouri West, together Evergy, signed onto a stipulation and agreement agreeing to identify and provide data, including information to study distribution system costs, customer and usage information, and some sample customer and rate design information. Specifically, Evergy agreed it would provide the information that had been set out in staff witness Sarah Lange's direct testimony in that prior rate case by July 1st, 2023. But if that specific requested data was not available or cost prohibitive to produce, Evergy would file an EO docket to explain the reasons why it cannot provide the requested data and give its individual estimate of the cost to provide each set of requested data for the staff and commission's consideration. Now, before I get into the actions or inactions of Evergy and what data or cost estimates have or have not been yet provided, I have a copy of the data commitments set forth in Ms. Lange's testimony. If I could approach. And this is basically what Mr. Fisher had up on the screen earlier, but.
Counsel, could we have a copy of that?
Oh, sure.
There's extra. I got to tell you, Ms. Kerr, I'm a little uncomfortable with having some exhibits during opening. Is this going to be admitted, or?
It's just for demonstrative.
Okay, let's go ahead and make sure all the council get a copy.
Thank you.
It's just the list.
Ms. Kerr, do you have a copy?
I have a copy. Now that just sets out the paragraph in the stipulation and agreement, and specifically sets out the paragraphs of the requested data, just for your reference. And like I said, the parties will likely reference this list many times, and May refer to the requested data by paragraph number, so just having that list in front of you, I thought just might help. And the reason that list was included in Ms. Lange's testimony and the reason for staff signing on to the stipulation and agreement, and thus the reason for this case even exists and why we're having a hearing today, is because staff did not have that information it needed in that rate case to do a meaningful class cost of service or COS study. Evergy's inability to provide customer count and customer usage information that was less than 6 months to a year old also gave staff many concerns throughout several rate cases. There are other narrower issue items on that list too, so I can start with those smaller pieces. There's an item asking Evergy to provide sample customers to staff so it can estimate bill impacts in rate cases. There's also a request for Evergy to study determinants for on-peak demand charges, something that industrial interveners have been asking for, and something that many or most of the co-ops in the state already do. Those on-peak demand charges are also being looked at by other companies, and their studies are showing some real progress. Another provision involves reactive demand charge, which is an incredibly complex engineering issue, but what the stipulation commitment relates to relative to the reactive demand charge portion of the data is really just reporting the meter reads where available. There are a few other things that take up a lot of room on the list, but many may actually be moot at this point because Evergy's metering and billing systems account for them internally, or they're already addressed with the rate codes. There's the need for customer and usage information to be split out by voltage and for the adjustments to be applied to meter data. While Evergy's testimony is unclear at this point, we think items 2A, 3A, 4A, and 5 are moot in that they're already handled internally. Now, the bulk of the information Evergy agreed to provide can be divided primarily into two categories: distribution data and customer usage data. With regard to the distribution data, the last time a close look was given to the distribution system cost was over 30 years ago, back in the 1990s, when significant work went into aligning the price signals of the rate structure that Evergy is still using today. Well, it's time to study it again, because number one, it's not been studied since then, and number two, the distribution systems today look very different than they did back in 1994. And as a result, the manner of calculating the cost to distribute the power has changed. In the last rate cases, Evergy was unable to answer staff's questions on how to estimate the cost of the secondary distribution system to exclude from the bills of customers at primary and secondary voltage systems, or to study the existing price differentials in Evergy's existing tariffs. Distribution system components are in the field for decades, but the system as it existed in the 90s largely no longer exists. It's now time to get an updated understanding of the cost of the secondary distribution system versus the primary distribution system, and to do a check of the existing Evergy rate structures, which charge customers within a class different customer and facility charges based on their sizes. Staff was disappointed that Evergy's direct testimony failed to give a line-by-line cost estimate for processes within the first stipulation provision, because that cost estimate could have helped staff find common ground alternatives that Evergy could agree to. The biggest pieces of information we need to complete the puzzle are reasonable approximation of the cost of running those primary and secondary lines. But we need this docket for resolution of discovery disputes to continue to develop alternative data for a distribution system study. The staff and the commission should be able to rely on information that's reliable, current, and accurate. This requires open and productive dialogue and cooperation from Evergy. With regard to customer usage data, we need to start with the basic understanding of two terms which will be used throughout this case: rate class and rate code. The rate classes are customer groups like residential, small general service, medium general service, large power service, and lighting. The rate codes are the actual sets of rates that each customer group pays. For example, residential default, low differential time of use, or TOU, and residential two-period TOU. Each of those is a rate code, which will be defined in Evergy's tariff, and they usually have identifiers that are letters and numbers like RPKA or RTOU3. I can try to do the handout. I also have a handout that I can use to demonstrative purposes, just that will be used later on throughout the testimony. Do you want me to hand that out?
Yes, we're here now. Go ahead.
That she uses the minimum general service or MGS rate class at Evergy Metro as an example for what we mean when we're talking about rate codes. It's the Evergy Metro MGS rate class, rate codes, and rate element pricing. It shows how the rate class is the first category, which then includes the rate schedule, which is broken down into rate codes, and they have different prices based on the voltage at which the customer takes the service, and assumptions based about the usage profile of the customers. And that's the level of data that was the subject of the stipulation and agreement, the rate code level where the rate prices are set. And this is the information that staff is requesting. That'll be used, that'll be referred to during some of the testimony later today and tomorrow. Now, according to the stipulation and agreement with regard to the customer usage data, Evergy committed to provide hourly usage by rate code and the customer account information needed to calculate average hourly usage for customers on each rate code. In recent rate cases, Evergy has only provided class-level hourly usage and only information for a time period that ended months to a year before the rate case was even filed. One of the most important uses of hourly load information is to study the responses of customers to weather during the study period so that staff can estimate what customer bills would have been had the weather been, quote, normal. Weather normalization is not a new concept, and in the past we have weather normalized all residential customers lumped together. However, with residential time-based time of use rates, we think and hope that all residential customers will not respond the same to the weather. In other words, staff cannot assume that a customer who pays a penny extra for using energy at 8 o'clock instead of 9 o'clock will react to a hot evening the same way that a customer who pays 35 cents extra for that peak energy will react. But without the hourly data, staff could treat that 1 cent customer usage the same as that 35-cent customer usage, and will end up giving the commission the wrong answer. That would be unacceptable. For the rate case Evergy West has noticed it will file in the next month or so, Evergy's data request responses, in this case, state that Evergy intends to use usage from July of 2022 to June of 2023. That data will be almost a full year out of date before staff even files this direct testimony. That means that any concerns or issues with how to normalize and annualize time of use bills will have to be dealt with in the true-up. That is not reasonable, and it shouldn't be acceptable to the commission. In the stipulation and agreement, Evergy not only agreed to provide this customer and usage data, but it also agreed to provide the information to staff upon request. Staff is not requesting this information for its own edification, but to actually perform its duties. To properly do its calculations, staff will need hourly customer and usage data by rate code for the test period, the update, and the true-up in each rate case. It may also be needed from time to time for MIA cases or other things of that nature. In recent cases, staff's update period selection has been dictated by Evergy's ability to provide billing data and Evergy's delivery is months behind that of other Missouri utilities. Now, Section 386, 762, sub 1 RSMO states that the Public Service Commission shall have the authority to review, inspect, and audit books, accounts, and other records kept by a utility or affiliate for the sole purpose of ensuring compliance with Section 386.754 to 386.764 and make findings available to the Commission. When Ms. Lange testified at Evergy's last rate case and asked for customer usage data, including rate code and customer account information and distribution data, among other materials, she had every right to do so, and she and staff had every right to expect the company to provide it. Evergy has an obligation under the stipulation and under the statute to comply with staff's request for data. Evergy signed a stipulation to provide very specific data, and if it couldn't provide that information, it agreed to explain what it would take to get that data. Staff is disappointed that Evergy's direct filing was not very clear on exactly what data Evergy can provide and at what costs, but we'll try to clarify that during this hearing. If you have any concerns or questions about what any of this information is, how it will be used, or why staff is asking for it, please ask one of staff's 4 witnesses who each pre-filed testimony. They are Sarah Lange, Michael Stallman, Kim Cox, and Jay Lubert. Sarah Lange will testify and can answer your questions about distribution cost studies and what information is needed to review the reasonableness of current tariff rates or to facilitate rate monetization. She can also address the overall framework of the 2022 stipulation and agreement and Evergy's lack of progress on deliverability of customer and usage data since these issues first arose approximately 10 years ago. You may be aware of the issues of deliverability of AMI load data has come up in prior rate cases, stipulations, and rate design docket. At this point, her specific recommendations are to leave this docket open for more discovery and to try to resolve remaining discovery disputes as staff continues to request information to complete this distribution system and demand charge studies, and to use this docket as a means to resolve areas where Evergy asserts it cannot provide requested data because production of this data would require it to perform additional analysis. The Commission should also order Evergy to produce on-peak period demand determinants by rate code for non-residential rate schedules and be ordered to define up to 5 sets of on-peak demand periods for the study. Michael Stallman will testify and is available to answer questions about the need for data to properly weather normalize revenues and determine system peaks and how that is changing. He recommends the Commission order Evergy to provide any usable hourly customer usage information by rate code along with the customer count information, which is needed to study the responses of customers to weather and to create the load information that is necessary to produce fuel and purchase power modeling and to estimate class level demands for cost allocation methods used by all parties to rate cases. Kim Cox will testify regarding the need for data for rate case billing determinants and the revenues derived from them. She will recommend the Commission order Evergy to provide the data requested dealing with customer count and customer usage information, or at least retain that information so it's available for use in future general rate cases. And Jay Lubert will testify about the problems with having limited access to company system data to compile information to help staff develop recommendations concerning fundamental issues in rate cases, which lead to information asymmetry between what data the company has and what the staff and the Commission has. As such, he recommends the Commission order Evergy to ensure the company provides staff access to actual hourly customer load data and accurate customer counts by rate code in a timely manner to avoid months of regulatory lag when processing rate cases. He also recommends keeping this docket open to resolve discovery disputes and to resolve issues where Evergy asserts it cannot provide the requested data. I'll be happy to answer any of their questions. Thank you.
Thank you, Chairman Root.
Great, thank you. I appreciate your opening. You made the statement that the Evergy's delivery of data is months behind other Missouri utilities. Can you expand on that? Or can you tell me who to ask?
Yes, I think the best person to ask would be Sarah. Would be our witnesses, either Sarah Lange or Kim Cox or Jay Lubert.
Are there any other commissioner questions? The judge has a quick question.
Sure.
Can you go back to your citation of a statute?
Sure.
You said that staff has the authority under 386, and I missed the last 3 numbers.
762.
Would it surprise you to learn that that statute directs the staff the authority to review compliance if a utility is providing HVAC services? I'm looking at 386-754 through 386-764. The heading, which for those listening is not legally binding, but it is put in there by the revisor of statutes, says utility companies dash HVAC services. Can you respond?
if I got the citation.
Okay, no problem. I totally understand.
Yeah.
Um,
I mean, I know,
If you do have a citation of law, let's make sure and put that in our briefs.
sure.
Okay, excellent. Thank you, Ms. Kerr. Let's move on. I think we are done with opening statements. And we'll go ahead and move on to our first witness. My understanding is that will be
Company
Sean
called
Riley.
Sean Riley, yes. Sean.
Thank you, Mr. Riley. Let me swear you in before we get started. Please raise your right hand. Do you solemnly swear or affirm that you will tell the whole truth during your testimony?
I do.
Thank you. And Evergy, the witness is yours.
Please state your name for the record.
Sean Patrick Riley,
Mr. Riley, where do you work?
PricewaterhouseCoopers.
What is your position there?
I'm a partner.
Mr. Riley, did you cause to be created what's been marked as Exhibit 5, which is your direct testimony in this case?
And I just want to remind counsel and witness to make sure and speak closely to the microphone for the benefit of our court reporter. Thank you.
That is correct.
Do you have any changes or corrections to that testimony?
I do not.
Are the answers in the testimony true and correct to the best of your knowledge, ability, and belief?
Yes.
Your Honor, I'd move for the admission of Exhibit 5 and tender this witness for cross-examination.
Okay, this is our first exhibit, just an information announcement to the parties and to those listening. I tend to go very fast through these. If there are multiple questions, I will combine them. I am looking for objections because of the way the commission does file its testimony. All the parties have had at least a few weeks, if not months, to review, and those objections would have been filed already. Yes, Ms. Kerr?
Staff objects to the filing of his testimony.
Excellent. Thank you. Can you state your reason?
We had filed our motion to strike because this, and we would use the same reasoning.
Thank you. That motion has already been denied. We will stick with that, but we'll make sure and add it on to the record. Evergy, your witness. Oh, I'm sorry.
Wasn't sure, was
No.
it entered into, was the exhibit admitted?
You're right. It has not been. I got done with my quick announcement and then got sidetracked. Okay, you've heard the submission, Exhibit number 5. Are there any objections besides Ms. Kerr's, which we have already dealt with? Hearing none, it is so admitted.
Thank you, and I would tender this witness for cross-examination.
Thank you, sir. And for cross-examination, we go first to Mr. Opitz
No cross, Your Honor.
and the public counsel
No questions, Your Honor. Thank you.
and staff.
Yes. Now, were you've been paid separately for your testimony today?
I will be.
And how much will you be paid for your testimony today?
It's going to be dependent on how much time is incurred. I don't have that calculation. We haven't done that calculation as yet.
Is it hourly?
It is.
And how much hourly?
It depends on the level of staff working on the job, but, so it really depends, anywhere from $200 an hour to $700 an hour, somewhere in there is my recollection.
Okay, thank you. No further questions?
Thank you.
Oh. I do have a couple hours.
Nope, you're good. Go ahead.
And how many hours have you put in so far?
I don't have that. Be difficult to guess.
Can you give an estimate?
100, 80 to 100, my guess.
Okay, thank you.
Thank you. That takes us to commissioner questions for Mr. Sean Riley. Any commissioner questions? Hearing none, the judge does have a couple. Does PricewaterhouseCoopers perform the financial statement audit of Energy?
Of Evergy?
I'm sorry, of Evergy, yes.
No, no.
Do you know if the FERC, that's Federal Energy Regulatory Commission, USOA, that's Uniform System of Accounts, do you know if the FERC USOA requires electric utility use of a specific rate design methodology?
Of a specific? No.
Can you tell me your experience with writing computer software code or generating report queries from utility customer data and billing software?
Certainly. I have zero experience.
Are you familiar with the National Association of Regulatory Utility Commissioners, that's NARUC? Are you familiar with the NARUC 1992 Electric Utility Cost Allocation Manual?
Yes.
Thank you. I believe that ends all the questions from the bench. That will take us to cross-examination, and we go back to MECG. Mr. Opitz,
No, thank you, Your Honor.
Office of the Public Counsel,
None. Thank you, Your Honor.
staff,
None.
and redirect company.
No redirect, Your Honor.
Thank you. Mr. Riley, you are excused from the witness stand subject to recall. Perhaps now is a good time to discuss Mr. Riley's travel plans. Please don't be very specific. I'm just wanting to know if you're going to be around tomorrow.
That is my plan.
Excellent. You are excused subject to recall. Thank you, sir.
Thank you.
And for those listening and for everyone in the audience, we are doing the subject to recall in this case because we are taking the witnesses one at a time and not according to issue, which is typically how the commission would have arranged this. So we're making sure that you're available for any follow-up questions.
I am.
Thank you. Let's go ahead and have Evergy call up their next witness.
Thank you. Thank you, Judge. The company would call Julie Dragoo.
Ms. Dragoo, please raise your right hand. Do you solemnly swear or affirm that you will tell the whole truth during your testimony?
I do.
Thank you. Evergy, your witness.
Please state your name and address for the record and your position at the company.
My name is Julie Dragoo. I work at the company headquarters at 1200 Main in Kansas City, Missouri, and my position is Senior Director of Customer Strategy and Support.
Did you cause to be filed in this case a direct testimony, which I'll tell you has been marked as Exhibit 1, and surrebuttal testimony, which has been marked as Exhibit 2?
Yes.
Do you have any changes or corrections that you know that need to be made to those pieces of testimony?
I do not.
If I were to ask you the questions that are contained in those Exhibit 1 and 2, would your answers be the same?
Yes.
And are they true to the best of your knowledge and belief?
Yes.
Judge, I would move for the admission of Exhibits 1 and 2 and tender the witness.
Thank you. Pursuant to my first announcement, you have heard the motion for the two exhibits. Are there any objections to the admission of Exhibit 1 and 2? Hearing none, they are both so admitted. And I believe you tendered the witness. That takes us to Mr. Opitz.
No cross, Your Honor.
OPC,
No questions. Thank you, Your Honor.
staff?
Yes, thank you. Morning.
Good morning.
Now, you reference on page 6 of your direct testimony, make sure I'm in the same page too. Actually, it's page 6 of your SIR rebuttal.
Okay.
Sorry. Oh, you referenced, quote, data requests number 4 and number 5, but you're actually referring to the items in the stipulation rather than data requests
Yes.
sent by the parties, right?
Yes,
Okay.
in the detail from Brad Lutz's feasibility assessment in his table.
Okay, so we can refer to those as something else for clarity?
Sure.
Right, okay. So when you're talking about the stipulation and agreement items, you're talking about stipulation items number 4 or number 5, right?
Yes,
Okay. So throughout your testimony, that's what you're
correct.
okay. So with regard to the program or database changes required to obtain the sum of hourly meter reads by rate code, or what's listed as item number 3, what did you?
Is it item number 3?
Well, yeah, let me get to the right page. So if we're talking about, yeah, item 3 on the stipulation,
I'm going to interrupt. I see that we have reached actual testimony, and we are talking about a piece of paper that has no foundation and is not entered as evidence. I understand it's a demonstrative exhibit, but I would really, really like to have it marked so that we can all refer to this document, because I've also just now heard you refer to it as the stipulation, which I don't recall there being more than one paragraph that's applicable here in the actual stipulation. It was attached, and it was in Ms. Lange's testimony, but you're referring to the original 9 or so questions, right? Go ahead. No, go ahead.
it's how Mr. Lutz was referring to them as well.
Yeah, no, I'm good with the reference. I'm following along. I want to make sure that the record follows along, so that in a couple weeks or a couple months, as we're all writing.
Okay, no, that's fine, I can just have it marked as exhibit, what do we, whatever exhibit number we're on,
That's okay. I've got 204.
204?
Is the next I have for staff. This is unusual, so I want to make sure and bring this to the company's attention. This is an unmarked 2 pieces of paper. I'm fine accepting it because I know what we're talking about.
Judge, this just reflects the stipulation on the data retention paragraph, and then I think it reflects the information that Ms. Lange requested in the original case and is now the subject, is in Brad Lutz's testimony. I have no objection to this.
Yeah, no, we've all read it 100 times, but I just want to make sure, because nobody has done a word comparison of these photocopied papers. So that's all.
I'll take staff's word that that's it.
Excellent. Any other objections? So admitted. That is Exhibit 204. I apologize for the interruption. Thank you both for helping me clarify and clear that up.
No, I'm sorry if I was causing some confusion with that. But Okay, so it's Exhibit 204? Okay. Yeah. Okay, so,
Perfect, thanks.
okay, do you have a copy of, was it marked 204?
Yes.
Okay, okay, I'm sorry about that. So if you look at, on the stipulation item number 3,
Okay.
so with regard to the program or database changes required to obtain the sum of hourly meter reads by rate code, what did you know in July of 23 that you didn't know back in August of 22?
So I just want to be real clear that I'm answering the correct question, because item number 3 is discussing the number of customers served on a rate schedule, and I think you're asking about hourly data.
Right, for customer accounts. Guess I don't understand what you're. The number of customers by rate code. What did you know in July of 23 that you didn't know in August of 22?
So maybe start again with the question, so that I'm clear on what it is you're asking. So, and maybe I can repeat it. Are you trying to understand what we know differently now than we knew in August of 2022 about providing the count of customers by rate code?
Yes.
So from my perspective, I wasn't involved in the conversations in August of 2022. So I can't say what was known differently then than now. But from my perspective, we've said in this
Okay,
docket here that this is available data and could be provided.
okay. All right, so if the, all right, I'll move on then. If the commission ordered you to provide a report of how many customers were on each rate code for each week of every month in the past year, would Evergy be able to provide that? Could you do that?
That is not something that we have evaluated, so I wouldn't be able to answer that question right now. I mean, a weekly count by rate code.
If you, a report of how many customers were on each rate code for each week of every month for 2023?
Yeah, this would be a depends conversation on what it is we're really trying to get after. So as discussed in my testimony, there's a variety of ways customers can be counted. And so just to make sure, we would need to know what is the expectation of that customer count by rate code, right? Is it customers who've been billed on that rate code? Is it customers who are just on that rate code but maybe have not been billed? So it would need to be further defined.
Okay. So if they were billed, could you provide that?
Yes.
Okay. If the commission ordered you to provide a report of the customer usage at each applicable voltage for each rate code by hour for the past year, could you provide it?
Is that effectively the question in item number 4?
I believe so.
And what would be the frequency? The answer is, as in our testimony, the data is available.
Each rate code
and
by
could
hour.
and could be provided.
You could?
Assuming that we had the time to build the information, test it, all of the things.
I'm sorry?
Yes, in our testimony, it says it could be provided.
Okay, how long would it take?
I believe we have the estimate in there for item number 4.
How many months would it take to produce it?
I don't have a month number. I have it by hours and based on the assumptions that we have made to provide this estimate.
Okay, and do you know how much it would cost?
We have roughly 360 hours, around 54,000.
Now, if the customers were on a rate code but not billed, did Evergy provide the customer accounts for 2023?
By what time frame? Yes. I mean,
Weekly?
that is not something we have discussed internally. So I would want to make sure I didn't commit to that with this estimate.
Okay. Where'd it go? May I approach? I hand you, this is 205? I'm sorry, we're at 205, right?
Yes, we're on 205.
I'm going to hand you. What's been marked Exhibit 205? That's Evergy's response to a data request in ER 2022-0129. It was Evergy's response to data request number 250.1. In that case, Evergy provided class-level hourly loads, correct?
State the question again. Class, at the class hourly loads.
In that case,
Yes.
Evergy provided class-level hourly loads, correct?
Correct.
And Evergy represented that those loads were derived from summing AMI meter data, correct?
Correct.
This response states that no voltage or loss adjustments were applied to the hourly load by rate class data, correct?
This is not a DR that I am familiar with, so that is what it says, yes.
Judge, I think Brad Lutz is the signatory to that. He could probably answer that.
Sorry? Okay. Well, I just asked that to offer an admitted.
This exhibit.
All right, I'll ask Brad Lutz those questions then.
Did you want to?
I would ask that that exhibit be admitted.
Okay. You've heard the request. Exhibit 205 purports to be the response to DR 0250.1. Are there any objections?
No objection.
Hearing none, this so admitted. Are there any further staff questions?
No, not at this point.
Thank you. That will take us to commissioner questions. Are there any commissioner questions? Commissioner Holzman.
Thank you. Thank you. Morning. I just want to sort of, get a little better understanding from a macro perspective. So your role is in the IT side, helping develop the systems that would potentially create the data that could comply with this request?
So I actually serve in the customer organization, but I have the teams that support the data analytics. I have the teams that do the configuration of the systems, but and do IT-ish work, but we are not in the IT organization.
Okay. So I'm looking at the testimony that Brad Lutz provided that sort of outlined what was available, what was, plausible, and then what was complex or difficult. Would you be involved in determining which of those levels that was graded out?
Yes.
Okay, so based on your response to the last staff question, is anything possible with time and money? I mean, is any of these systems could be done if you had unlimited resources and unlimited time to accomplish the requests?
Sure, yes.
Okay, so then it's a matter of determining the cost-benefit analysis of putting that effort into the new systems, because the way I read Mr. Lutz's testimony, there are just some that the way that you currently are collecting data, it's not designed to produce that end result, which is what's being requested.
Correct.
So then the real question becomes, what of the requests are critical to the ongoing work of staff?
Yes.
Okay, that's what I wanted to try to get to. I think I'll have more questions for Mr. Lutz about which ones. Are there any of these requests that you would consider to be, even though they're in the realm of cost, time, plausibility, that are just not feasible?
Data request number one.
Data request number one, because of the cost associated with it. I don't know if that's is that a confidential cost?
No.
Not anymore.
No, so we're looking $80 to $100 million for number one.
Yeah, I think the way you have to look at that from our perspective is just this is an ask that's never been made before. So we had to kind of take a look at all the different sort of transformational type efforts that we've done in the past and what that might cost. And so without a defined scope of work, it's really difficult to get much granular than this number.
Okay, all right. Thank you so much.
Yep.
Thank you, Judge.
Thank you, Commissioner. Are there any other commissioner questions for Ms. Dragoo? Commissioner Hahn?
Thank you, Judge. I can't remember whose testimony I read it in, but also in Mr. Lutz's testimony, it does say that some of the data is available, and that in one of the testimonies, I can't remember which one, but if the commission is interested in that particular set of data, that we should order it. Is that still, have you provided any additional data to staff since that testimony, or if it is available, would Evergy's position be that we still need to order it?
Yes, so our position here is that this has been looked at collectively. So at the point we're at now, we have not provided the specific requests.
Okay, thank you.
Thank you. Are there any other commissioner questions? Hearing none, the judge does have a few. Does Evergy currently track line transformer costs and expenses?
I'm going to leave that to Mr. Letts.
Okay. I'm going to go ahead and run through these just to make sure. Primary distribution costs and expenses.
Mr. Letts?
Secondary distribution costs and expenses.
Mr. Letts?
Primary voltage service drop costs and expenses.
Mr. Letts?
Line extension costs, expenses, and contribution.
Mr. Letts?
And meter costs.
Mr. Letts?
How about voltage class or rate code, questions involving those two terms?
As it relates to the asks in this, potentially, yeah. I can probably answer some of
okay.
those.
Yeah. Besides capital investments and maintenance expenses, which are tracked by voltage class and rate code, according to Mr. Lutz, are there other cost or expenses that are tracked in categories by voltage class or rate code? I'll give you some examples. Operating expenses and costs, regional transmission organization fees and expenses.
Mr. Letts.
Okay. We were so close. And my last question. If Evergy does not track those costs by rate code or voltage, how does it determine if it is recouping the appropriate revenue from those customers?
Mr. Letts.
Okay. We took a try. Thank you. That does take us to recross-examination. Let me find my cheat sheet. I believe that goes to Mr. Opitz.
No, thank you, Your Honor.
And then Public Counsel.
Sorry, Your Honor, no questions.
Thank you. That will take us to staff.
Yes. So you told Commissioner Holzman that it was difficult to estimate costs without a defined scope of work. What action did Evergy take to define that scope of work for stipulation item 1?
As I mentioned to Mr. Holzman, Evergy had to look at this as a holistic, tops-down estimate because there were refined business requirements, right? So it was difficult to do a bottoms-up estimate without specific items to describe how our systems would need to work to make this data available.
Okay. Did Evergy consider looking at the items listed in stipulation item 1, item by item?
No, we did not.
Okay. Thank you.
Thank you. Ms. Kerr, I believe that takes us to redirect.
Yes, Judge, a few questions. Mr. Adgu, you were asked about your role at the company and the cost-benefit analysis. Would you explain what your involvement was and what did you do to estimate the cost, particularly of the data requests in 1 that are most problematic?
Yeah, absolutely. So, as mentioned, my team works on a lot of transformational projects. So I have the project delivery team for the customer organization. So we have worked on our large projects in the past, and so we have a familiarity of what these large transformational type of projects would cost. So we took that expertise along with the knowledge that this would be a really new concept in the industry. So there weren't any industry benchmarks for us to attempt to use to say, well, it could cost about this much, right? It'd be a brand new review of scope, of requirements, of that kind of thing. In addition, it's not just a change in systems, right? So it's a people, process, technology. This would be a huge organizational change management effort for Evergy.
Would you explain the difference between, I think, what you referred to a tops-down or a bottoms-up approach?
Sure. So again, tops down is a high level estimate. So how we first look at projects at Evergy is really kind of, here's the shirt size, and I think I mentioned that in my testimony, right? Is it small, medium, large, extra large? And then that gives us the way to say, okay, this is an extra large effort. We need to spend some time to do the benefit analysis of what this project brings to the company before we can go and spend the money. Once those things are decided, then we would take the approach of a bottoms-up estimate. And we would say, okay, now we really need to go and define exactly what it is we're trying to accomplish with a solution and write business requirements, define and design how that's going to work. And that's what it would take to really hone in on a very specific estimate.
Would you explain from your perspective why it's problematic to make these changes to capture by voltage and by rate code?
Absolutely. So the way our systems work today, they're set up specifically for that individual process. So you think about our billing system that would have rates, including rate codes. Our MDM is going to have the usage that then flows to the billing system for billing. But our work management systems, our property accounting systems, even our PeopleSoft do not track customer level information in those systems, right? They're looking at those assets, they're looking at the, creating our financial statements, and those are not tied to a voltage or rate code.
Commissioner Hahn asked you some questions, I think, about some of the data is available. Are you the witness, or should I ask Brad Lutz to go through what is available and what we think we've already done? Or do you have some aspects you should?
I can have some aspects of that,
Would you?
particularly with the billing.
Would you go through
usage
that
information.
with the commissioner?
Sure.
Or with me for the commissioner?
Yeah. So if we start with number 2, do you just want to go through this list?
Yeah, that'd be great.
Yeah, absolutely. I think I explained a little bit about number 1 just now. Number 2 is the total number of customers served by the rate schedule. We have said that this is data that we have available, that we can track. It is not tracked in the fashion that is asked for in this request or item, whichever way we want to describe it at this point.
So it's not available in exactly the format staff asked for it, but it is available?
Yes. And we did notice also just in the rebuttal and in some other data requests that the asks continue to expand, particularly for this particular ask. So customer count by rate code has also now become by billing cycle. And so while we put an estimate forth here, if we continue to work with others on this particular item, we would have to reevaluate this ask or this estimate. Number 3 is very similar to number 2, but I believe this is the one that just is asking for customers that don't have interval data or do have interval data. So it's a very similar ask. If worked in tandem, I think would not, we estimated these individually. If worked at the same time, could be a reduction in these 2 items. Number 4, that is the hourly usage summed by rate code. That is information that could be made available. It is not information that we have readily available because it's not an analysis that we as the company have done. We do store the data. We have the interval information for our customer usage. Interval, yes. Hourly, yes, interval. And so we do have the information. It would take some effort to build the system, build the data, define the requirements of how we would put this all together and sum it by rate code. Number 5, if we were to go through this one, I think, originally we believed this to be a different ask, which we assumed was the any adjustment to any kind of usage would need to be sort of a real-time update. And so thus the larger estimate, we believe through rebuttal and some data requests, as this is specific to voltage adjustments and should be available just through our regular metering and billing information.
And so your estimate that you've included in the original testimony would be less for that?
Absolutely.
Okay. Is it available today?
Yes. Not in the format asked, just to be real clear.
Okay.
It would be in the same qualification as like number 4. We'd have to work to put that all together.
Okay. Go ahead with your list.
Yes. I'm having a hard time, so I'm put this a little closer to my face. But number 6, this is the request that is the from time to time the commission may ask for additional information without any real, we marked this red with complex delivery. It's really hard to predict what might be asked. So it's hard to give an estimate on what it might cost or what it might take for an ask that we don't know what it is. Number 7, this relates to interval data being retained for a minimum of 14 months. We don't believe this is applicable. We don't think it's a request other than just a statement to retain, and this is happening at Evergy and is occurring right now. Number 8, retain individual hourly data for use in providing bill comparison tools for customers to compare rate alternatives. Again, we are retaining the individual hourly data. This is for use with customers in their rate compare information right now. We're on applicable meters and applicable rates. So we don't believe this is an ask as much as a yes, Evergy is retaining this information. 8B, retain coincident peak determinants. I'm going to let Mr. Letts cover this one. I believe 8C is related to Part 1, which we covered, and we'll let Brad Letts cover that one. 8C2, a minimum of 12 months of data described in Parts 2 through 5. Again, for the individual items, those should be available, providing additional months' worth, again, the estimate to build those data sets. 8C3, I would package C, 8C3 and 8C4. These are requests for individual customer samples. Again, we have the data, we are storing the data, we use the data. The deliverability is such that it would need to be limited based on the hourly data and a small sample size, so no more than 100, and it would be this cost estimate every time to build that report, since it would be a new set of customers most likely. And then I will say 8D, this is 36 months. We discussed looking at the individual items above, right? So assuming that does not include item number 1, for places where we have 36 months of data stored in our data hub, which I mentioned in my testimony, that would be available. And then I'll let Brad speak to number 9.
Judge Hatcher asked you about a number of areas that you said should be discussed with Brad Lutz related to line transformers, primary distribution, secondary. Do you recall that?
Yes.
Are those costs, are those areas particularly important for data request number 1 rather than customer usage or data requests?
Yes.
Okay. Ms. Dregu, do you, in your work with your group, can you explain what groups you worked with to come up with the cost estimates?
Yes, in particular for the items that are related to the billing and usage information, those would be the folks working specifically on my teams, the systems who support that team, the data analytics team who work in that data on a regular basis, our IT partners who also manage the data warehouses and the data hub. For the estimates related to item number 1 around distribution by rate code and voltage, we used a large cross-section of company experts from our distribution systems support teams, our accounting support teams, the experts.
I'm going to object. I think we're going past what we've discussed in direct and cross.
Response?
Judge, I'm just following up on the cost estimate process that was discussed with the judge, with the judges, or with the commissioners, I'm sorry. And she's explaining how that was developed and who was involved.
Yeah, I'm going to overrule that.
Go ahead, I'm sorry.
Yeah, so a large, a cross-section of experts with the systems, experts with our accounting practices, experts with our accounting systems, a wide variety of folks.
Do you believe those folks that you worked with in developing those were operating in good faith?
100%.
That's all I have, Judge.
Thank you. And I would notice that it is just a few minutes before the noon hour. We will be taking a lunch break before we get to Mr. Lutz's testimony. Ms. Dragoo, I want to ask about your travel plans. Please don't give me any details. Are you going to be available for recall tomorrow?
Yes.
Thank you. You are excused from the witness stand, subject to recall. Let's take our lunch break. Are there any pressing announcements we've got to get taken care of in the next 30 seconds? Seeing none. Let's go to lunch. Return here at 1 o'clock. At 1 o'clock. We're off the record. Back on the record, the hour of lunch recess having expired. We are on the company witnesses.
Mr. Brad Lutz is our next one.
Thank you, Mr. Lutz. Come on down.
If I could just do something on the record.
Excuse me.
This is Carolyn Kerr. During my opening, you had asked about the statute that I had cited, and I just wanted to update that, if I could, before. Do you want me to do that now?
No,
Okay.
I'm sorry. Opening statements are over.
Oh, I know.
Well, let's move on to
Okay.
witnesses. You can put that in your brief, though.
Okay.
Thank you.
All right, thank you.
Hey, my turn. Let me see where I'm at. Please raise your right hand. Mr. Lutz, do you solemnly swear or affirm that you will tell the whole truth during your testimony?
I do.
Thank you, sir. Evergy, your witness.
Please state your name and address for the record.
My name is Brad Lutz. My work address is 1200 Main Street, Kansas City, Missouri.
Are you the same Brad Lutz that caused to be filed direct testimony and sir rebuttal testimony in this case?
I am.
And I believe your direct has been marked as Exhibit 3 and your sir rebuttal is Exhibit 4.
Okay.
Do you have any changes or corrections you need to make?
I do. For my sir rebuttal,
Okay, would you go to your sir rebuttal and identify your changes?
yes, these will occur on page 26 of my sir rebuttal. These were the result of an exchange with staff through data request 210. And my correction would begin on line 10, page 26. Instead of referring to confirm the company response is appropriate, satisfying the data request, I would instead point that row to the equivalent line on page 25, row 7. And then for row 20, also on page 26, related to item 8D.
Well, before you do that, would you read what it should be, or for the record?
Yes, so begin on line 10, page 26. Okay. Line 10 currently says, for data request number 8B, comma, confirm the company response is appropriate, comma, satisfying the data request. That should instead say, for data request 8B, the commission should reject this item. And then secondly, on row 20, page 26, it currently says for data request number 8D, comma, confirm the company response is appropriate, satisfying the data request. It should say for data request number 8D, confirm appropriateness of the data requested and approve regulatory treatment for prompt company recovery of expenditures to deliver the data requested. And again, I would refer to data request 210 as being the basis for that change.
Are there any other changes?
No, sir.
Okay, if I were to ask you, with those changes in mind, if I ask you the questions today, would your answers be the same?
They would.
And are they true and accurate to the best of your knowledge and belief?
They are.
Judge, with that, I would move for the admission of the 2 exhibits and tender the witness for cross.
Before I take up those 2 motions, I would like to request a,
Errata?
yes, please, as an exhibit, just with those changes. We'll set a due date for a week or 2. We'll discuss that at some other point after the hearing. And let me get your number.
4 and 5, I think.
Well, 6 will be the errata sheet for Lutz. And I will include that in my orders, notice of orders given during the hearing. Mr. Kleiser.
Sorry, I was waiting for you to call for objections.
Okay. You've heard the motion from the company. Exhibits 3 and 4, we'll take them together. Are there any parties with objections? Mr. Kleiser, you have an objection?
Yes. As I was following along with the corrections being made, it appeared to me that they were not actually corrections, but rather updates. And therefore, I would object to the updates being made. I would posit that I am willing to wait for the errata sheet to be filed and to file my objections correspondingly then, because I want to verify, but otherwise, those don't appear to be corrections. I don't object to the body of the testimony otherwise.
Understood. I had the same concern, and I would rather deal with it now rather than delay it until afterwards.
Well, Judge, if I ask him, would his answers be the same today as they were when he filed it, his answer will be no, because they're not correct today. And that's what we're trying to update.
Correct? Are you correcting or changing position?
Well,
If you're changing position, I think we let in his testimony, we don't have any objections, and then, we're certainly going to come back to redirect. And
okay,
then
well, we can do it that way. That'd be fine.
Go ahead.
If redirect would not be a cure in this situation, because the principal problem is that the other parties, staff and myself, have not, and MECG, have not had an opportunity to really digest the nature of the change being made. So, for example, I don't need to provide an example. I think you get my point.
Judge, could I ask just another question to Mr. Lutz? What's the nature, why are you making this change, and what's the nature of it?
The section that is being updated is a summary of the company positions in that testimony. And in the data request exchanges with staff, it was highlighted that the improper summary was reflected. So this would change that language to reflect our position offered in that testimony.
To reflect your existing position that was a typo in the summary? Or is this from staff's DRs after you submitted your testimony?
It definitely
That's-
occurred after.
Okay, not a correction. I would like to find a path forward so that we can take his testimony and then,
Really quick.
boy, I don't know.
Yeah,
Go ahead.
let me, so, just repeat really quick, what were the changes? You don't have to do this, just, which two of those letters were it on page 26?
Your Honor, perhaps if we could have the errata sheet by the end of the day and we could hold admitting testimony at this stage. If we do have another day of hearing tomorrow, perhaps the parties could review the changes overnight.
That sounds like a path forward. Any objection, Evergy?
We may be filed tomorrow morning, but we can certainly get it put together.
Tomorrow morning is the offer on the table?
This is for just the errata sheet.
By tomorrow morning, perhaps by 8 a.m., at least giving us a couple of hours before the hearing is scheduled to start.
Well, we got a little correction on that one, too.
8 a.m.'s fine.
Sold.
With
We'll
that,
be-
then, are you, so I didn't object to the actual body of the testimony, so that's going to be offered and accepted. Is that the case? No, okay.
I'm going to ask at 8:05-ish tomorrow morning. Is how I understand. I'll take nods. Okay, yes, we're going to do that. Let's go ahead with Mr. Lutz's testimony then, and we will hold the admission of his direct and sur rebuttal and errata sheet and ask tomorrow morning. Excellent. Evergy, your witness.
Well, I moved for admission of both exhibits. You're going to hold both till tomorrow. I can do that and tender the witness at this time.
So tendered, let's go to the cheat sheet for cross-examination. I believe that is going to be Mr. Opitz.
Good afternoon, Mr. Lutz.
Good afternoon.
Is it fair to say that the company's position, as outlined in your testimony, is that the core of staff's, it has concerns that the core of staff's requests in this case extend beyond what is necessary in the company's operations to provide service to customers?
Generally, yes, in that the requests in many ways have asked for things that are not operationally available.
So, were you in the room for opening statements this morning?
I was.
And do you recall counsel for Office of Public Counsel talking about the three core functions of the Public Service Commission, I guess when designing rates or looking at a rate case?
I do.
At a high level, that was looking at the revenue requirement, looking at the cost allocation, and then looking at rate design, correct?
Correct.
In your experience, the company's been able to develop revenue requirements without the information requested by staff in this case, correct?
That is correct.
And the company's been able to perform class cost of service studies without the information requested by staff in this case, correct?
Also correct, yes.
And the company's been able to develop rates for each class without developing or compiling the information that staff is requesting in this case, correct?
That is correct.
And you've been able, Evergy has been able to bill customers without the information that staff is requesting you compile in this case, correct?
That is correct.
And one of the arguments for, I guess that was outlined by the staff for the reasons they need this data is because they need to develop throughput disincentive information. Am I summarizing that correctly?
That is one.
Evergy's been able to develop energy efficiency charges without this information requested by staff.
Yes, thus far, yes.
They've been able to develop fuel adjustment clause charges without the information requested by staff.
Yes.
You've been able to develop RESRAM charges without the information developed by staff.
Yes.
You've been able to develop, although I don't think implement yet, securitization charges without the information requested by staff, correct?
Yes, with your caveat. No,
And Evergy also has, at least in the past couple rate cases, previewed that it has a rate modernization plan. Is that correct?
that is correct.
And that's to touch on how rates look for customers in the future. Is that right?
Correct.
And within those cases, the company has been willing to consider alternative proposals for rate designs by the parties, especially taking into account customer preferences or customer choices. Would you agree
I'm
with
going to
that?
object to that. I'm not sure how that's relevant to the information in this case. And the council also referenced a case. I'm not sure what case he's referencing.
Mr. Opitz?
Sure. Whether the company is able to or has been able to develop these, I think gets to some of the core of what this case is about. I mean, what this information is going to be used for. The staff's testimony and the company's testimony touches on, well, this information is or is not needed for various aspects of either allocating cost or designing rates. And then as to the second point, so I think it's relevant there. As to the second point, when I referenced, I think I referenced the case, I was talking about rate cases. I'm going to try and remember the case numbers, but I believe 2 rate cases ago was 0185, and I think the most recent one was 0135 and 0136, and those would be ER docket numbers.
Judge, if I could weigh in too, I agree with Mr. Opitz. I think this goes to the heart of one of the issues in the case is rate modernization. What data do you need to go forward, and what's going on in that area right now?
With all due respect, I think Mr. Opitz has made his point. I think that this particular question has extended beyond the scope of what we've specifically been referencing in the testimony of this case.
Mr. Opitz?
So she's, I guess, can I clarify what question you're referring to that you believe is beyond the scope of the testimony?
Can I have the court reporter read back Mr. Opitz's last question? I apologize for making you do extra work.
Your Honor, I guess in the interest of moving forward, I'm,
Where in those cases, the company has been willing to consider alternative proposals for redesigns by the parties, especially taking into account customer preferences or customer choices. Would you agree with that?
Okay, the question is on the table. Mr. Opitz, did you want to go ahead and withdraw that question? Is what I thought you were going to say?
no,
Okay.
I think that question stands that, the company has taken into account customer preferences in its past rate cases.
Can you tell me how taking into account customer preferences in its previous rate cases relate to the requests for data from the company?
Certainly, the staff in its testimony and in its statements here has suggested reasons why this information is available. And I think among those are that they have inadequate information to do their job as they see it. And I think the company's willingness to consider customer preferences that are raised in rate cases cuts against any need for the creation of this additional data, additional systems to prepare and provide this data.
And I will renew my objection that I do not believe that the staff's job in a rate case is to consider customer preferences. I believe it is to evaluate the data and provide the best recommendation that takes into account all factors.
I'm siding with staff on this. The question talking about customer preferences certainly is a valuable one in that context, but here, the only customer preferences I have seen in testimony has been whether customers would prefer or not to pay for the request. Objection sustained. The question is, go ahead, your next question.
Everything else I had went along those lines, so I'll just finish there, Your Honor.
Thank you. All right, let's move to Office of Public Counsel.
Thank you, Your Honor. Good morning, Good afternoon, Mr. Lutz.
Good afternoon.
I always get that messed up. How you doing?
I'm okay. How are you?
I'm good. All right. Hopefully, I'll keep this relatively brief. Your Honor, I'd like to mark an exhibit. I believe it should be 301.
Yes, 301.
I need one copy myself. All right, thank you.
Thank you.
Your Honor, while this is in the process of being handed out, I will alert you, I'm going to do these three in quick succession and then move for their admission at the end to save time. All right, while she's getting that handed out, Mr. Lutz, you would agree with me that this is the company's response to OPC DataQuest 1, correct?
Correct.
All right. Like I said, I'm going to keep moving right ahead, so I'll mark the second exhibit, which would be 302. Okay. Fine.
Thank you.
I'll give them both.
Mr. Kleiser, just for identification purposes, how do you see that this is DR1?
Yes, Your Honor. It is actually question 1, which is directly under.
I see the question 1.
No, that's literally it's just DR1 because it's literally question 1.
Gotcha. Thank
Yeah.
you.
That is confusing, though.
Yes.
Exhibit 302, so marked. As
And-
DR2.
Yes, and while I'm at it, I will go ahead and just mark for the exhibits OPC 303, which will be DR3.
So marked.
And if council will afford me, I will speed things along. I think there isn't going to be much objection to this. So, Mr. Lutz, would you agree with me that OPC marked exhibit 302, which is the Evergy response to OPC data request 2?
It is.
And can you also agree with me that what has been marked OPC exhibit 303 is the company's response to OPC data request 3?
It is.
Thank you. All right, Your Honor. I would move for the admission of these 3 exhibits.
You've heard the question. I'll combine all 3. Are there any objections to 301, 302, 303? Hearing none, they are also admitted.
Thank you. I'm not actually going to ask you about those. I needed them on the record, and you were the one to lay foundation. So,
Okay.
Just very briefly, would you agree with me that in any traditional rate case, there are multiple parties who take an interest in the question of rate design?
Yes, I would.
And that would include interveners such as the Office of Public Counsel, MECG, or any other party that might have an interest in that?
I agree with that.
And you would agree with me that those other parties will occasionally put forward their own rate design proposals in whole or in part?
Yes.
I have no further questions. Thank you.
Thank you, Mr. Kleiser. That will take us to staff.
Thank you, Your Honor.
Thank you.
Mr. Lutz, I just handed you a copy of Ms. Sarah Lange's direct testimony that was filed in ER 2022-0129 and 0130. I have also provided a copy of that to the commissioners and the judge, the court reporter, and the remaining counsel. Would you agree that that is a copy of what I have handed you?
That's what the title states, yes.
Thank you. So the commission approved the stipulation and agreement that was filed in 0129 and 0130, and that included a provision that stated the company will identify and provide the data requested in the direct testimony of Sarah Lange, along with some more provisions that was actually referenced by your counsel in his opening this morning. Is that correct?
That is correct.
And the testimony that is referred to is the testimony that you are now holding. Is that correct?
I presume so. I mean, it seems to be the same.
Taking my word for it that
Yes.
it is a copy of what was filed in EFIS in that case.
Yes, ma'am.
Thank you. I would like to move for the admission of Ms. Lange's testimony from the rate case 0129 and 0130 at this time.
Thank you. I have 206 as staff's next exhibit number. Hearing no corrections, and this is the direct testimony of Sarah Lange from the previous Evergy rate cases, plural, ER 2022, 0129, and 0130. You've heard the motion. Are there any objections to the admission? Mr. Fisher?
Judge, I would not have an objection to the introduction of an excerpt from this testimony that relates to this case. There's much information here that's not relevant, and I would object to the introduction of that testimony.
I would argue that the testimony in its entirety explains why it was referenced in the stipulation and agreement and what the issues in the heart of this docket that we are now arguing this hearing in are regarding.
Perhaps you could point out one example that does not fall within pages, whatever it is, 62 to 64. Can you cite one example within this testimony outside of the portion that is specific to the data being requested?
Judge, I just flipped to 29. I mean, it says, what's your recommendation acknowledging extreme pricing events? That's not related, not relevant at all to this case. Now, her testimony where she does explain what she wants, that's clearly relevant, and that excerpt would not be a problem.
It would be hard to cherry pick. I mean, looking right here at page 25, we talk about the class cost of service studies and the interclass revenue responsibilities, which I believe is involved in this case. And again, this case is born out of the conversations in that rate case.
But you're not asking for every piece of testimony from the rate case to be admitted.
I mean, we could make that offer, but I assumed that Ms. Lange's was the most relevant, being as that it's referenced in the stipulation and agreement.
Judge, she could ask my witness a question about something in it, and that would be perhaps relevant, but just to introduce a piece of testimony from another docket that clearly addresses many, many other topics other than what's relevant to this case is not proper.
I am coming down on Mr. Fisher's side. I'll give everybody one more chance, but the quick quote I saw on page 25 is complaining about the lack of information, no detail about what information is being sought or why it's not available, which is, to me, the gravamen of the case.
I am going to ask questions about this throughout the course of the cross-examination, so I will offer the testimony again at the end if that's acceptable.
Yes, let's see what the questions fall on what pages.
Thank
Excellent.
you.
Let's go ahead.
Evergy has raised concerns about the quantity of data requests that were requested in this docket. Is that correct?
The quantity of requests?
The number of data requests.
Oh, yes. Oh, I'm sorry. I was conflating it with the data requested. Sorry.
No,
Yes,
the actual
yes.
number of
Yeah,
data
the-
requests.
the Over 200 data requests, is that the reference?
I believe that is correct.
Yes.
Would you trust me if I told you that 87 of those data requests are duplicative because of the unique qualities of Evergy Metro and Evergy West?
No, I would agree with that. I mean, the caveat to that is we still have to process each one regardless of the duplicative
Thank-
question.
Thank you, Mr. Letz, and staff does acknowledge that.
Okay.
But you do acknowledge that, just as you said, you have to process each one differently, but also each division has its own separate books, records, costs, and so forth, correct?
From an accounting perspective, yes, but in many ways, we operate similarly.
Okay, but accounting is really what we're getting at the heart of here, correct?
For data request one, I believe, yes.
Okay, thank you. Let's talk about a few of the data requests. I'm going to go ahead and see that a copy is handed around here. Regarding staff's data request 176, I'm going to give you an opportunity to get that and take a look at it. That request asked if Evergy was able to determine on a given day the total number of customers served on that day by Evergy Metro, Evergy West, and to please explain the process taken that would determine the total number of customers served on a given day. Is that correct?
Yes, that appears to be the nature of the question.
And Evergy responded that yes, it could determine the customers served for the two divisions on a given day, but stated that a query would need to be developed in order to pull the desired type of customers by rate code, customer class, or any other characteristics for the two divisions to perform a count function. Is that also correct?
It is correct.
So, given the identified person at Evergy, if we were to ask them to provide a list of the number of customers on each rate code each day for the last year, 365 days, what is the absolute earliest day that you think Evergy could give us that information?
I don't have an answer for that other than to point back to the data sets. Maybe I'll use that differentiation, the data sets that we responded to under BDL 1. And there's a close equivalent for item 2 and maybe item 3 is where we provided estimates for something similar.
So Evergy could provide that alternate information that it's identified in your schedule.
Yeah, the key issue being is that the data is available. It's not a question about the data, but it's about the details of how it's delivered and how is it exported out of the operational systems and made ready for the purposes of staff.
Okay, what would be the earliest time frame that Evergy believes it could provide that alternate information?
The best I could offer would be what's in BDL 1. I don't have any kind of expectation for what that would be based on this question alone.
Okay, so the level of detail we could expect is what is already in your schedule BDL 1.
That's all I would offer here. Much like when Julie was up here earlier, there's details. We would have to look through those details to determine if there was anything problematic in the request to know for sure what that timing would be.
Okay,
So I have to defer to the ones that we've offered in the pre-filed testimony.
okay. Would the cost that it would take to produce what is located in BDL 1 now be the same as the cost that we would expect, say, a year from now?
I hesitate because there's a lot of issues that could be caught up in that to complicate it, but I would say generally, it should be similar.
Okay. And does Evergy believe that it could produce a list like that, say, in an update period for a rate case?
Right, now, you bring up an important context around rate cases. You know, the rate case itself has set out very specific parameters around the use of a test year, update periods, true-up periods, and the company is aware of those and plans for those in its execution of a rate case. So something done in that context is definitely more achievable because the company has anticipated that and takes steps to deliver that information.
Okay, if staff chose the update period, would that change your answer?
As long as there was some time for us to prepare for it, I think that we can be flexible on information like this, which is related to customer billing, the items in, say, data set 2, 3, 4 from BDL 1 that are customer related. I think we have more opportunity to find what you need there.
Okay, thank you. And Schedule BDL 1, since we've referenced it so many times, that's attached to your direct testimony? Thank you,
Correct.
just for everyone's edification. I am going to go ahead and hand around another DR response. This is staff's DR 177.
Thank you, sir.
And just to be clear, this DR request identifies the same questions that I've just asked you, but it asks you based on the volume of energy sold in a given hour to retail customers. Would Evergy be able, are your answers the same, or do they differ based on the volume of energy?
No, the answers are the same.
Okay, thank you. I would go ahead and offer both DR 176 and DR 177. That includes staff's question as well as the company's response.
I have marked data request 0176 as Exhibit 207, and I have marked data request 0177 as Exhibit 208. You've heard the question. I'll combine them both into one. Are there any objections to the admission of Exhibit 207 or 208? Hearing none, they're so admitted.
Thank you. I am now going to, and by me, I mean Ms. Lange, thank you for your assistance, hand around a copy of staff's DR 197.
Thank you.
And this request regards Evergy's statement that it intends to file a rate case for Evergy, Missouri West in the near, I would say the near future in 2024. And asked if the TOU transition intends to be reflected in that filing. And Evergy responded that the residential customers on TOU rates would be included, but they expect it to be of minimal impact and not to result in significant changes in the company's supporting documentation, along with some other responses. Is that correct?
That sounds like my testimony, correct? Is that what
Okay.
that's not this data request? That's
Yes, I have the same question.
I'm sorry, but yes, I'm sorry, your testimony is quoted at the beginning of the data request, but yes,
Okay.
it references that. Can Evergy produce class-level hourly data for a period that is more recent than July of 2022 to June of 2023 for use in the future rate case?
could you repeat those dates, please?
Absolutely. It is July of 2022 to June of 2023.
Can the company produce data
Class-level hourly data,
newer?
newer than July of than June of 2023.
Yes.
So, if staff were to request the data for July of 2023, say, to January of 2024, would Evergy be able to provide that?
Sorry, say those dates one more time.
July of 2023 to January of 2024. Also for class level hourly load data.
Class level, yes, I believe we would.
Do you know how long it would
Well,
take?
that's what I was going to say. I would prefer that it not occur within the context of like discovery. If there was some way to know about that early in the process, I mean, that allows us to fit that in around other operational needs. But yes, I think class level data is achievable through January of 2024.
What would be the earliest date that you would expect you would be able to produce it?
I don't know the answer to that.
Okay.
Again, maybe, I don't know if this is helpful, but I mean, the balance here is that the company has to consider these data requests from staff in the context of other things. And we have to make sure that we're, in a sense, keeping the lights on and still achieving these asks. So there's a balancing that has to take place within our teams. The people that Julie mentioned and all of the people that work with her are conducting billing and doing the day in and day out business of the company. So that's where the
Absolutely.
time is valuable to make sure that we can get it delivered when you need it, but also in a time that can work for us.
Absolutely. I mean, I think everyone acknowledges that we all have jobs to do, and
Sure.
it
Well,
doesn't only center on Evergy data.
Right. And I guess what I'm trying to move outside of is the discovery process has often been a constraint to this dialogue between us because so much of it's occurred within the data request process and its timing. And that just is a constraint that's difficult for us for us collectively to navigate. So if we can do things outside of discovery, I think then there's much more opportunity to reach some kind of a good solution.
So the company might be open to the idea of having a docket such as this one to further that effort.
Well, yeah, with a number of caveats. I mean, this docket itself is problematic for ongoing discussion and detailing out what we do here. For example, the discovery terms that are established for this case are just not sustainable. We agreed to accelerated turnaround because of procedural schedule limitations. That can't persist. Things like that are problematic for this docket being the vehicle going forward. I do agree we need some means, some method. I accept that the only way we're going to resolve this is for us to continue to talk through it and work it out. It's just a matter of getting the right guidance and the right information to help lead us to an answer.
Can I ask you what Evergy's preferred route would be?
Yeah, I mean, it's complicated, certainly, and forgive me for having to ramble through this just a little bit, because we have this EO docket that we have to resolve. This has been created and kind of has a life of its own. But I think staff would support me in this, that the solution is not in these 10 data requests or data sets. The solution is something additional, something different that we've maybe collectively now have new understanding about each other and what we can do and what we can deliver. So I think that the solution can be similar to this, but it can't be constrained by the construct of the EO and these 10 items. It would have to be some kind of a proceeding, but separate from this.
Thank you. I'm going to go ahead and proceed on, but certainly food for thought. I'm going to go ahead and hand out another data request response. This is staff's DR 213. And this DR specifically asks about the timeliness of the data that's been provided by Evergy and relied upon by Evergy in the past general rate cases.
Well, I maybe recharacterize slightly. I mean, I think that this is just expressing the dates that were set for the periods. I don't know that it discusses timeliness per se.
Well, it discusses the dates that were set, the
Yes.
test year and such,
Yes.
particularly based on Evergy's data availability.
Maybe I'm uncertain about that. I was under the impression that these dates were largely set at the beginning of a rate proceeding through interactions with the parties to set what would be the checkpoints, if you will, or the touch points for the timing.
Well, that actually goes to my first question about that. The customer and usage information that was used in the 2022 rate cases was July of 2020 through June of 2021. Is that correct?
For the, I'm sorry,
For the pair of rate cases that are referenced specifically in this docket, ER 2022-0129.
right, so it was,
0130.
so you're referring to the test year being the 12 months ended June 30, 2021.
Correct.
Correct, yes, I agree with that.
Okay, but that data was over 1 year old when the rate case was filed, correct?
No, the filing date was 6 months later.
When the direct testimony was filed, though.
The company's direct testimony?
The company's direct testimony, yes.
Was filed on January 7th, the first column, which was about 6 months later. Am I reading?
The oldest data would have been 18 months old at that point, so July of 2020, correct?
Yes, I believe that's been our convention through at least the number of rate cases that I've been associated with since about 2005, is that the test year is historic and usually follows roughly about 6 months earlier than the filing date for the company testimony. So I think that this, and if you look at the list of these cases, you'll see similar behaviors.
That's actually, yes. The 2016 and 2018 cases trended about 6 to 8 months
Yes.
of data.
Your Honor, if I could just interrupt. I think I'm going to interpose an objection to this line of questioning on the grounds of relevance to this case. I don't understand, and maybe staff counsel can clarify, why this is relevant to the current problem.
So staff is asking for the data that it is asking for moving forward. We are trying to obtain the relevant data in order to make our best recommendations in future rate cases. And we have concerns about the timeliness of what is being provided historically, and that is part of the reason for our ask that are at the heart of this case.
The objection is overruled. You can go ahead and answer the question.
Thank you. And actually, the last thing I wanted to verify about that is the update and true-up periods only are in regards to billing data. Is that correct?
Yes, to the extent that it supports the revenues associated with the rate case filing.
Okay.
Now,
Thank you.
I mean, just to be clear here, the intent of these is to update the company case.
Correct.
Now, what I wanted to be careful is because the issues here in here are often more about updating the staff's case. The data retention issues are around staff's data, not the company's.
And
position.
what is
So there's
usually provided in the update period is what updates the company's position, correct?
Correct. So all of
Thank
our
you.
commitments here are related to our proposals and our case. The stuff that's here is more addressing staff's position.
Thank you. Moving on, do you have a copy of your direct that was filed in this case?
I do.
We've already said it many times. If you could turn to your Schedule BDL 1.
Yes, I'm there.
And can you tell me, did you provide any work papers to support the cost estimates that are identified in that schedule?
No, because of the top-down nature of what the approach was used, there were no work papers that would be considered in a classical sense, where you might have itemized costs similar to Mr. Kleiser's data request that he gave me. Those were seeking an itemized build-up, ground-up estimate. The company did not do that, so there were no work papers in that form.
Okay, and the company does not have that to date either, correct?
Correct, correct.
Okay.
This being a transformational level project, similar to what Julie Dragoo was talking about, it required a different approach to produce the estimate.
Okay, thank you. And do you have a copy of your SIR rebuttal as well?
I do.
All right. And on page 4 of your SIR rebuttal, at lines 14 to 16, you state that you trust that staff in Evergy took appropriate care in recent Evergy rate cases to make sure that data and assumptions used in those cases was appropriate. Is that correct?
That's what I said, yes.
Thank you. Going back to Ms. Lange's direct that I provided you, at the beginning of my questioning, if you could go to page 25 of her testimony.
I'm there.
And through page 36, line 6, that testimony is Ms. Lange's description of how that she did not find the data appropriate to conduct a reliable class cost of service study. Agreed?
Correct, that's the testimony here.
Thank you. And then referring back to your direct testimony, I apologize to make you keep switching through documents.
I'm okay.
At page 23 of your direct. You reference an excerpt from the commission's report and order that was issued in ER 2022-0337.
I do.
And I am going to go ahead and hand around a copy of that very quickly so that we can have that in front of us. Yeah, isn't it? I apologize, Your Honor. I might need to take a brief recess to get a copy of that.
We're needing paper copies to distribute to counsel and the witness. Question?
Yes, I need a copy for the witness. I apologize.
Your Honor, well, she's in the middle of working on that. I might have missed the thread. Was question 0213 marked?
Yeah, it is, I have not announced it. I've marked it as Exhibit 210. I'm waiting for a motion. I'm also waiting for a motion on 209. Given her past practice, she seems to question the witnesses and then moved for 207 and 208 jointly.
Perfectly fine. I wanted to make sure I had the numbers right because I thought I had missed them. That was all.
I apologize. I will go ahead and move for the admission of 209 and 210 at this time. I do have that 207 and 28 were admitted. Is that correct, Judge?
Yes.
Thank you.
I'm letting the company attorneys consult for just a second. And go ahead.
Judge, I don't have an objection to it. I will have some follow-up on redirect.
Okay, I'll ask my official question. You've heard the motion on Exhibits 209 and 2010 being DR 197 and DR 213 respectively. Are there any objections? Hearing none, they are both so admitted.
And I apologize. We are retrieving a copy of the, but I will go ahead and I will move on from there. Going back to your Sir rebuttal testimony. At page 16, you state, I believe it is worthwhile to note that there are two distinct groupings of data requests driven by purpose. One set associated with obtaining data to support rate design, and a second set to support cost allocation. Numerically based on the presentation in Schedule BDL1, I would characterize data request number 1 and number 8C as related to cost allocation, and the remainder related to rate design. Is that correct?
That is correct.
For clarification, I know we've said this multiple times, but they are referenced as data requests in your testimony, but they are actually the specific provisions of the stipulation and agreement from 0129 and 0130, correct?
Yeah, the reference to 1 and 8C1 are for those data sets, yes.
Thank you. So your testimony would be that you characterize items 2, 3, 4, 5, 6, 7, the remainder of 8, 9, and 10 as rate design allocated, correct?
Correct. I would offer maybe a little bit of a distinction for 9 and maybe 9 and 10, depending on the context of how it's referenced, the critical peak and the reactive demand. I might isolate those in the cost-related as being forward-looking as well. I think there's some distinction that's worthy of those two as compared to the remainder. But generally, yes, I'd agree with what you just said.
Okay, thank you. I'm not sure if you have a copy of your rebuttal testimony from the 0129 and 0130 dockets.
I do not.
That's fine. I can hand that around.
Thank you.
And if you could turn to page 20 of this testimony.
I'm there.
Thank you. And if you could go ahead and recite, beginning at line 12, the question that is seen there.
Yes, it says, what is your position concerning the staff recommendation to retain data related to on-peak demand charges and reactive demand? And it says, I support the intent of these recommendations, but must clarify that the company will study these only where study only those rates where a reactive demand charge is part of the current design, or a demand charge could be added without material configuration of customization of the company metering or billing systems. Should I keep going?
No, yeah, I'm sorry. Yes, please.
The staff recommendation appears inclusive of all rate codes. Demand charges are not commonly associated with residential customers. Reactive demand is not commonly associated with residential or small commercial and industrial customers. To devote study to those customer rates would not be practical with this initial effort.
Thank you. And you did not provide, Evergy did not provide a study of on-peak demand or reactive demand determinants prior to July 1 of, prior to this date for rates where a reactive demand charge is part of the current design or a demand charge could be added without material configuration of customization of the company metering or billing systems, correct?
Would you repeat that question?
Absolutely. Evergy has not provided a study of the on-peak demand or reactive demand determinants for those rates where a reactive demand charge is part of the current design or a demand charge could be added without material configuration of customization of the company's metering or billing systems.
The company has provided the determinants and proof of revenues related to those, but no study beyond that has been offered.
And what date was that provided for?
Well, it would have been in the course of the rate case.
The 2022 rate cases, correct?
Correct, the context of this testimony.
Okay. When did Evergy decide not to study the reactive demand and on-peak demand determinants as is referenced?
Decide not to study. I don't understand the question.
So in your testimony that you just recited from, you said to devote study effort to those customer rates would not be practical with this initial effort.
Yes, I was just reacting to staff's proposal to do such studies. It was rebuttal testimony.
Okay, so it's not a formal Evergy decision not to study those things? It was just,
In the context of this case,
okay.
I would say that.
Okay, thank you. Other than the testimony then, Evergy has not communicated anything regarding not performing these studies, correct?
The only thing that's been said since this testimony was a reference made in my rebuttal, I believe. I spoke to it just very briefly, I think, in these testimonies as justification or my concerns around data request 9, or data set 9.
So the rebuttal in this docket in 0002?
The rebuttal.
I'm sorry, the rebuttal, yes,
Yes.
the rebuttal in this docket. Okay,
Yes.
thank you.
Yes, and that was the nature of my comment a moment ago about these being somewhat forward-looking, because these are issues that are still, I would consider pending in our jurisdiction. The proposal to institute critical peak or coincident peak demand or reactive demand charges have not been yet made for Evergy.
Out of curiosity, though, Evergy Kansas Metro residential customers do have an optional rate with an on-peak demand charge? Is that correct?
Yes, that came to us through our changes in the net metering laws that occurred in the Kansas jurisdictions that gave us opportunities to propose different rates for customers. One of the other rates came to us through our merger with Westar. It was a pre-existing demand rate that came over from Westar.
Okay, thank you. I will go ahead and offer Mr. Lutz's testimony from the 0129-0130 case. This is his rebuttal testimony.
You know, Judge, I'm not sure it's all that relevant, but I'm not going to object. If they want to put our position in the record, that's fine.
Mr. Kaiser?
This document is labeled as confidential. Am I understanding correctly that the exhibit is being offered as confidential?
Yes, this would be offered as a confidential exhibit based on the testimony that was identified as confidential at the time of its filing.
Yes.
Okay, I'll go ahead and ask. Exhibit 211, which is the entirety of Mr. Lutz's rebuttal testimony from Evergy's prior rate case, which is file number ER-2022-0129 and 0130. Are there any objections to the admission of Exhibit 211? Hearing none, so admitted.
Are all of Evergy Missouri Metro's customers AMI metered?
Yeah, the vast majority. There's only a small number that have exercised voluntary opt-out.
And is that in regards to the residential customers or?
No, I believe that all of our customers, all classes, have some level of AMI.
Okay, so are all of your large power customers AMI metered?
Yes, for the purpose of delivery of the meter reads for billing, yes.
Okay, and large general service?
Yes.
Okay, and that includes medium general service, small general service?
Yeah, to the extent those classes exist. Our Missouri West jurisdiction does not have a medium class, for example.
Correct. And then residential customers, anyone other than those who have opted out?
Correct.
That's correct. Are the lighting customers at all AMI metered?
It depends. Our lighting schedules, we have metered and unmetered, so it would depend on that character of service. But if to the extent they were metered, they would be through the AMI process.
Okay, do you have any idea on the number on that, or?
Oh, no.
Okay. And like you said, Evergy West, it would be large power, large general service, small general service, and then residential customers who haven't opted out?
Correct.
Okay. And the same for the lighting customers and on the west side?
Yes.
Okay. Now, what I just listed there are not rate classes per se, but your tariffs do reference rates by rate schedules and rate codes. Is that correct?
Correct.
Okay. So Evergy Metro's medium general service class has 2 rate schedules, MGS and MGA?
Yes.
Okay. I am going to hand around the relevant tariff sheets for those 2 rate schedules.
Thank you.
Thank you. And I'm offering you these again with the caveat that these, I am certifying that these are the currently effective tariff sheets for the MGS and MGA rate schedules for Evergy, Missouri Metro.
Yes.
And then, probably should have just handed this out immediately. This is actually what was provided at the beginning, but just for reference, this is the Evergy Metro MGS rate class, rate codes, and rate element pricing table. And then on the back, it is the Evergy Metro MGS rate class, rate code pricing comparison. And I do not believe that this has been admitted. It was offered at the beginning, and I'm not offering it this minute, but I am going to ask a series of questions regarding it. So what I've handed around here at the top has a table with the heading class, and under that it says MGS. And that shows the 2 Evergy, Missouri Metro rate schedules that fall under the MGS rate class and provides rate codes, rate description, and the tariff sheet on which that information is found. Do you accept that this is accurately the reflective tariff and then the table that represents that?
I would accept that.
Okay. Then there's also a second table that provides all of the rate elements in the MGS rate structure and the pricing for each rate code. And do you accept that?
On the back side?
Yes.
Yes.
Okay. Yeah. And on the back side, there are 4 tables. Correct. The top left table shows the prices for each rate element in 1 MGSE and 1 MGSF rate codes, and then provides the dollar difference and percentage difference and so on. Do you see that?
I do.
Okay. And looking at the tables on the left side, those compare a secondary service rate to a primary service rate. The top is general service at each voltage, and the bottom is for all electric service at each voltage. Is that correct?
Yes, it is.
Okay. So if I was a customer using 205 kilowatt demand, then I would pay $112.65, no matter whether I'm served at secondary or primary voltage, and whether I'm general service or all electric, as long as I am an MGS class customer. Is that correct?
Say that 205, I'm trying to find that number.
Absolutely. So if I'm a customer using 205 kilowatt demand,
Okay.
the charge is $112.65,
For the customer charge.
the customer charge, correct?
Yes, that's for billing, metering, and the sort, yes.
And that's regardless of being at secondary voltage, primary voltage, general service, or all electric?
Yes.
Okay. And now I'm going to hand around the stipulation and agreement that was entered into in case number EO-94-199, fondly referred to as the 90s case, already I think a few times in this docket. I am happy to report that we are not questioning about the entire 40-page document. But appendix, so this document is dated effective July 9 of 1996. And on page 21 of the overall packet, that's Appendix A to this to the order, and that would be the stipulation and agreement that was entered into in that case and approved by that order. So footnote 2 on that page says, a summary of rate design changes is attached as Appendix A. Wait a minute. I apologize. I am actually referencing what is listed as page 8 of this packet. And it is page 4 of the original stipulation and agreement that was filed in this case. And on that page, there is a footnote 2 that says a summary of rate design changes is attached as Appendix A. This summary is intended as the commission staff's and KCPL's explanation of the various rate design changes and is not necessarily agreed to by other parties to this proceeding. Do you see where I'm referencing that?
See where you're at?
And KCPL refers to your predecessor, correct?
Correct.
Okay. So now if you will turn to Appendix A that's referenced, which is at page 21 of the packet. There is a title there, Features of the New Commercial and Industrial Tariffs. And there's a section on that page listed Unbundled Charges. Do you agree that this section was describing the rate structure of the commercial and industrial, or C&I classes of KCPL in the mid-90s when this took effect?
That appears to be the case, yes.
And these elements are actually still found in the rate structure of the C&I classes at Evergy, Missouri Metro and Evergy, Missouri West today. Is that correct?
I believe that's true.
Okay. And can you please read aloud the statement on customer charges, which is the second full paragraph there on that page 21?
It begins customer charges, comma, which recover the costs associated with metering, comma, billing, comma, customer assistance, comma, and facilities on the customer's premises, comma, will be implemented for all customers. These charges will be specific to both tariff and the customer size.
Thank you. So now going back to the Evergy Metro MGS rate class, rate code pricing comparison document that I handed around. And that's what is currently in effect for Evergy, correct? For Evergy Metro.
The pricing that you see
Yes.
here?
The rate code pricing comparison table.
I accept that.
Okay. For all of the MGS rate codes, the customer is paying a customer charge that's determined by their annual demand and the fact that they are a MGS rate schedule customer, correct?
Yes.
Okay. What facilities on a customer's premises are supposed to be covered in those customer charge, in that customer charge? Would that be meters, transformers?
Based again on the excerpt that you had me read, it does not say specifically in the excerpt that was read, because all of these things would have been outside of the location, like meter reading, billing, customer assistance. Sorry, I see it now. The facilities on the customer premise. So for me, that would be the metering for that respective customer. I apologize.
Okay, thank you. Can you tell me about transformers for metering? Would that be included?
Are you referring to the transformers that provide service or specialized transformers like current transformers or potential transformers that might be used in the execution of the metering?
For both, if you can.
Well, the former, the transformer that provides service to the individual location, in my opinion, would not be part of these unbundled charges. That transformer sets further into the grid, if you will, and not at, potentially could be poles away from where the customer is located. But there are specialized equipment that's used in conjunction with the meter to allow for metering that could be incorporated in those unbundled charges.
And those would be CT and PT
Yeah,
transformers?
the current transformer, potential transformer were the two things I referred to. Yes.
Okay, thank you. I just want to make sure it's clear. Do you know what FERC accounts would hold each type of those?
No, I do not.
Okay. And Evergy has not filed testimony on cost of service for the customer charge referenced by that in the 2022 cases or any of the other rate cases going back to 2006. Is that correct?
Testimony?
Testimony.
I would agree there's no testimony, but I would have to point out that within the cost of service studies, there were specific allocators and allocator studies that were offered to support those that would have explored those costs.
Okay, and do you know when the last time those would have been studied and provided in the class cost of service, or in the cost of service study?
Yeah, for each case. So the most recent would be under the ER 2022-0129-030 cases. That would have been the most recent. But in my experience, that information has been provided with every cost of service study that we've performed. It underlies the allocation of the metering costs within that study.
And would that have been broken down by the transformer size?
Not transformer, it would have looked at the metering that would have been going for those particular customer classes. We would work directly with our metering team to determine what are the common metering components that we would use, and that helps derive the customer charge that we would propose.
Were those done by the class level or by the size level that's identified in the MGS tariff?
I would have to just say with the class, there's some blending because the metering folks out in the field do not see the execution of putting a meter and that equipment into the field in the same way we do for rate making and regulatory purposes. So there's a little bit of a gray, but generally I would say class is the right way to look at that.
Okay, thank you. And can you please go back to the tariff sheets, the Evergy Metro tariff sheet 10E?
Yes,
And it is titled Metering at Different Voltages.
yes.
And that says that Evergy Metro may install metering equipment on the secondary side of a primary voltage customer's transformer. And then the company can install compensation metering equipment. But if they don't, the metered usage will be increased by 2.34% when the bill is calculated. Is that correct?
Correct.
And is that 2.34% an approximation of the loss in energy that occurs due to the transformation of voltage, often referred to as line losses?
I hesitate to draw it that plainly. So I would probably say no out of caution.
Okay. That same tariff provision does reference that the company may also, at its option, install metering equipment on the primary side of the transformer for a secondary voltage customer. In this case, the customer's metered demand and energy shall be decreased by 2.29%, or alternatively, compensation metering may be installed. And so that 2.29%, would you be willing to reference that as a line loss or same
No,
caveat?
I mean, let me characterize it this way. I think what is happening here, what you're seeing in these tariffs are legacy conditions that have been maintained, that over time metering has different capabilities, and maybe modern metering, excuse me, would not need to be adjusted in these ways because of its advances. And we've retained these on our tariffs with the caveat that the company may use these if necessary. And what I mean there is if by chance there's metering that's older or something that's still out in the field and being used, we have this ability to compensate for that deployment in the field. But it's not necessarily inherent that all metering would be subject to this adjustment.
Okay, thank you. I believe you've answered my question. But what the caveat there that you just provided is only in regards to my reference to line losses, not to the customer charges, correct?
Can you say that again? I need to connect the two.
Your hesitation is in my reference to the percentages being attributed to line losses. The customer charge is still correct.
Right, line losses are generally attributed to energy or one of the other components on the bill, not a customer charge.
Right, thank you. Okay, referencing back to the Evergy Metro MGS rate class pricing comparison table, the energy charges that are listed in the tables on the left side, the percentage differences for those energy charges for customers served at secondary versus the customers served at primary range from that 2.29% and the 2.34% that are stated in the tariff for metering at different voltages. Is that correct?
Yes, I believe I see that close.
Okay,
Yes.
thank you. That's all I have. Okay, going back to the 1996 order, again, I'm sorry for
Okay, now you're all right.
pulling back, and going to page 21 of that order. There's a heading on that page called voltage distinctions.
Yes,
And it includes the statement, the levels of the demand and energy charges reflect the differences in losses at various delivery voltage levels. Is that correct?
correct.
Would you expect the non-summer tail block difference from line loss percentage is intentional or attributable to rounding in relation to that statement?
The non-summer tail block for the energy charge?
Yes.
To be rounding, I'm sorry, I'm coming back to rounding. Can you restate your question one more time?
That element is slightly less than the approximate 2% values of the other two. Do you believe that that is intentional?
Oh, that I don't, it's difficult to say, because in the practice of rate making, you often have remainders or small values that you have to account for, and they could appear anywhere. A tail block is a commonplace where that might occur, so I could acknowledge that, but I can't say for certain that that's the reason, but it's a plausible justification for why there's a variance.
Okay, thank you. Shifting now to the two tables that are on the right side of that sheet. And these compare the pricing of rate elements for secondary customers on general service rate codes versus secondary customers on the all-electric rate code that's at the top table. Is that correct?
Yes,
And then the bottom table compares the pricing of rate elements for primary customers on the general service rate code versus the primary customers on the all-electric rate code on the bottom table. Is that correct?
correct.
focusing on the energy charges still, the summer energy charges are identical in each table. Is that correct?
Yes. Or the summer?
The summer energy charges, yes.
For one MGSE versus MGSF? What, say again how
Yes.
you're looking.
Yes, for one MGSE versus one MGSF.
Because I see, for example, the first block of the energy charge is 0.10953, and then below that in the bottom right quarter, I see 0.01691. I see two different numbers. Am I in the wrong place? I'm on the back.
I think you're referencing the non-summer, but I'm gonna verify real quick.
I'm looking at the first 180-hour block of summer.
Okay, yes, there is a slight difference. But then looking at the non-summer energy charges for all electric customers, those are about 12 to 16% different than the general service customers. Do you see that?
I do.
Okay. And now going back to the 1996 order on the 21st page again. Under unbundled charges. It states all tariffs will have energy charges based on the customer's hours use, monthly load factor. These charges, which recover time of use costs, provide price incentives to customers to improve their load factor. Do you agree with that statement?
Judge, I think I'm going to interpose an objection. He's being asked to, for a long time now, to interpret a document that is even predates his time at the commission, at the company, and that goes back about 20 years. This is 27 years ago, and he's being asked to interpret what was being said at that time, how it relates to our current charges, which are a subject of rate cases, rather than the question of should the staff's data be produced and what cost is it, and should there be an AAO to account for that, and should the commission be giving us guidance on how to prepare rate design. This is just totally irrelevant to the case, and I'm going to object to any further question along this line.
Your Honor, Mr. Lutz has admitted that the rates that are referenced in this are still ingrained in the C&I customers' rates to this day. And with all due respect, the reason why staff is here asking for this data, the point of this case, is because we are trying to get updated data, and some of this data is stale to the degree of the mid-90s.
Which is their long-term view of rate design.
The 90s case is not at issue here. And I don't know that staff has a complaint or has any allegation that there's been any violation of this agreement. Can you tell me why we're...
Ms. Lange references the 1990s case in her testimony. It is relevant to the data that we're asking for here and some of the studies that we reference in our request for this case. DR1 actually points back to that 1990 stipulation.
Mr. Fisher?
Well, I would say if they thought it was relevant, it could have been attached to their testimony.
That seems like a good point, since we're just now hearing about it and we're midway through day one of the actual hearing.
It was referenced in testimony. I intended to offer it here. I can't turn back time and attach it to testimony at this stage. I thought it would be sufficient as an exhibit.
It seems like a risky strategy. I'll take it under advisement. Do you have any more questions on Exhibit 2? And I also need to stop and talk about our exhibit numbering. I think I might have mislabeled a couple. But first, let's finish up on Mr. Fisher's objection. Exhibit 213, staff, did you have any further questions on this?
The only question that the only remaining question I had was that the statement does say that it recovers time of use costs. Is that correct?
It says that, but I would caution everyone about the context, because time of use that we talk about today is different than the time of use that an hour's use is designed to recover. There's a lot of distinction there that we should be cautious about. I mean, what I would also point out, I'm not sure where you were going, but we have to acknowledge that there's been a lot of rate case activity between the 1990 and the current pricing. Like, especially in this all-electric example, we had interveners that challenged the existence of those rates, and they were specifically frozen and made unavailable to customers due to a customer's intervention a few years back. And steps were taken to purposefully increase those prices at a higher percentage than any other rates. So relationships that you might see today are not because of the 1990 effort, but are because of things that happened in between the 1990 establishment of the rate and all of those rate proceedings that affected change on it to where we are today. So that's an important distinction to keep in mind too, that commission action ultimately resulted in some of these changes that you're seeing today.
Can you tell me what the difference is between the time of use that's referenced here and the time of use as we know it today?
Well, correct, yes. This is what's called hours use, which is a different approach of dealing with time. And if you looked at the tariff that you provided me, the medium general service tariff, there is a section that talks about the determination of hours use. And really what it is a relationship between the demand and the energy of that customer. And in a sense, what it's doing is it's just looking at how that customer utilizes energy across the billing period to determine a load factor of sorts and providing advantageous pricing to higher load factor customers. It's not looking at hours of a day, like if you think of our residential rates where it looks from 4 to 8 p.m., that's not occurring in hours use. Hours use is a relationship measure where true time of use as we look at it today is looking at hour blocks associated with the clock.
Okay, so there is a change in the type of analysis used for the time of use today than there was in the 90s.
Right, so the phrasing for time of use could be misleading in today's context because we've used time of use to refer to what we're doing in the residential space today, where we have specific hours of peak, off-peak, super off-peak. That's not what we're talking about with hours use. It's entirely different.
Okay,
So I would
thank
just
you.
caution that difference.
Then I will move on from that exhibit. I would offer the exhibit, but I imagine that we're going to run into the same discussion that we just had.
No, let's take just a second, because this is a good stopping point for me to square up my numbering, and then we'll get to whether you want to offer that or not.
Okay.
Okay, I'm going to start at 210, and I'm going to move forward from there. For Exhibit 210, I have DR 213. For Exhibit 210, I have DR 213, and it has been admitted.
That's correct. That's what we have.
For 211, I have tariff sheets, which I'll need a copy of, and I have that has been admitted.
We have 211 marked as Mr. Lutz's rebuttal in the 0129-0130 case.
Excellent, because I also have 211 as Mr. Lutz's rebuttal. There's my numbering. Thank you.
Okay, and actually we have 212 as the tariff sheets.
212 is the tariff sheets. Mr. Lutz's is 211, it has been admitted. 212 is the tariff sheets. Does that make 213?
The 1994 order.
What happened to the rate codes?
The rate codes were actually offered at the beginning by Ms. Kerr,
Oh, I thought you were,
and they have been identified as 205. I apologize. I tried to clarify that when I was handing them
It's not
out.
what we have, Your Honor. We don't have that the rate codes were ever admitted.
They were not admitted. But they were offered and labeled at that time, to our understanding.
We have Exhibit 205 as DR 205.
I did not offer,
that's
that.
correct. Ms. Kerr never offered that.
I just handed that out as a demonstrative
Okay, then
piece of evidence. just
Then I would
because-
go ahead and number that now.
Excellent. I am going to, I believe we have all labeled as number 213 the order approving stipulation that we
Yes.
may or may not be getting objections on.
Yes.
So that makes
The rate codes.
214
214.
the rate codes.
Yes.
Excellent. I'm going to take 212 and 214. What I expect not to get any objections, not to lean on anybody. Are there any objections to the admission of Exhibit 212 and 214? These are tariff sheets and rate codes. Hearing none, so admitted. Staff counsel, please make sure I get a paper copy of your tariff sheets. Thank you. Never mind, I got it.
I was gonna say, I believe I did offer them around, but I know it was very rapid succession.
No, you did, we were just, I misplaced mine. Great, we got that taken care of, never mind on that. So now we are at Exhibit 213, which is the 1996 stipulation and agreement. Staff,
I would offer it for admission because it was referenced in testimony and it has been identified as having items in it that are still in the rate structure of Evergy to this day, which is what we are discussing in this case.
are there any objections?
Yes, Judge, I would object on relevance grounds. She has been able to cross-examine on anything that she thought was pertinent, but this entire document, although I've signed it 27 years ago, I don't think it's relevant for this case.
Mr. Kleiser?
I would also join with staff, and the reason I'm making this is because based on the body of testimony that's occurred just now, I anticipate that I might have cross-examination of Ms. Lange when she takes a stand relevant to this document. So even if it were to denied here, there's a possibility it would come up again, and I just want it to be cleaner. Specifically, it would appear that staff's argument is that they are basing current rate design on a 20-year-old document, and we need to get that fixed. That appears to be the relevance of the whole point.
The company's objection is upheld. This is a 27-plus-year-old document. This has not been mentioned as a relevant issue in this case, except for whatever mention was made that this was cited in testimony. Denied. Let's move on.
I apologize, Judge, if I could have just 1 minute.
Go ahead.
Okay, moving on. Considering the differences in demand charged in Evergy's currently tariffed rates for customers that are on the general service rate versus all electric, whether an MGS customer is served at primary or secondary voltage, an all-electric customer will pay a non-summer demand charge that's around 41 to 42% higher than a general service MGS customer based on what we've looked at here. Is that correct?
can I just take your word for that? Or are you going to point out to where that 40% number is occurring?
That is based on the tariff pages that we have been referencing.
Which ones? The medium?
Yes.
Are you looking at the medium specifically?
Yes. That is on the rate code pricing comparison tables, the bottom right quadrant. That's looking under Schedule MGS rates for primary service compared to Schedule MGA rates for primary service,
Got it, I see that.
under demand charge.
And what's your exhibit number, counsel, I'm sorry?
That is 214.
214, thanks.
And just please note that anytime you're referring to the all-electrics, those are the ones that were subject to the freeze and the special treatment that occurred after that freeze. So I would just urge caution in using that as a comparison.
Okay, so they're paying 41 to 42% more because of a special treatment that occurred after a rate freeze?
Right, I would contend that when that came up before the commission, the party that brought it forward asserted that there were discounts associated with heating, and those needed to be rectified. And so subsequent cases, the heating rates were increased dramatically higher than the non-electric rates that I'm sure upset this balance that you're starting to explore. But, I mean, just carefully too, I mean, the other part is that the demand charges are carrying the bulk of the generation capacity costs that the company is experiencing. So I think that I would offer is part of the reason for the difference as well.
Okay. So hypothetically, if a customer had a 500 kilowatt demand and the difference in the demand charge was about 90 cents per kilowatt, then that would equate to about a $450 per month difference.
If I can, subject to check, accept your math, I acknowledge a difference.
Okay. And then given that equation, that would equate to about $3,600 over 8 months.
Okay.
Okay.
Now, sorry, but if I'm following the line of questions, I'm sensing that there was some desire to equate some of that to distribution costs.
We're honestly just trying to understand
Okay.
what's in the tariffs.
Okay.
So, and based on some of what you've already testified, the last time that Evergy did a study for the all-electric rate schedules that was distinct from the general service rate schedules would have been for direct testimony in ER 2009-0089.
Can I ask that you clarify what you mean by study? I think there's been some significance attached to that word, and I want to make sure that I answer in the right context. What is the nature of a study that you're describing?
The last time that Evergy looked separately by classes for the all-electric versus the other rate customers.
Under that definition, I mean, it's difficult to say because I could offer that in each of our rate cases, we provide cost information that could be used to analyze those relationships. But it's been my observation that that is seldom done, seldom looked at. The cost study information by class is given, but it's not utilized in the rate making. So to say we study it, I would offer to some degree of your definition, we study it in every rate case.
When would be the last time that Evergy had separate hourly or demand data?
Hourly demand data.
For all electric versus the general service.
If you're simply looking for the determinants for it, it's available in every rate case in the proof of revenue that we provide.
And that's based on hourly load?
It's based on the measure for the tariff billing. So if it's based on a coincident or non-coincident peak or an hour's use or a kilowatt hour, it would be on those bases. It depends on the element.
But not by hourly load, by a different measurement? Or at the class level of demand?
I think that's fair, but I have to be careful. I mean, we're starting to really get into the weeds about how you break apart the rates and the pricing, and there's a disconnect often between the way the cost studies might reflect it versus the way we execute in the case because of policy considerations, impact, concerns for gradualism, all of those things factor in and mitigate the data, mitigate the detail that we might offer in a cost of service study.
So essentially, the data that's being provided is based on a so essentially billing data and hourly load data would be two completely separate things. Is that correct?
Correct. There's going to be data offered usually in the form of demands, non-coincident demands in the cost of service study, and the billing determinants might be something different. That's true.
Okay.
It depends on the allocation methods that are applied to those accounts.
Okay, thank you.
Yeah.
Okay, so then, continuing to look at the rate code pricing comparison document, which is Exhibit 214. There's a difference in the facilities demand charge of 17.13%, where a primary customer has a discount of 55.2 cents from the facilities charge of a secondary customer. Do you see that?
15. Is it on this sheet again?
Yes.
Okay. And the number is 15?
The number is 17.13.
Okay. Now I'm with you now. Yes.
Okay. Is that, okay, to start, that would be less than the, wait a minute. For a customer with a 500 kilowatt hour demand, 500 kilowatt annual demand, that would be a difference of $276 a month. Does that sound correct?
I'll accept it.
Okay, that would equate to $3,312 per year. But that's less than the $3,600 difference in billing demand charges for an all-electric customer that we referenced just a bit ago, correct?
I'll again accept that. I'm starting to lose track of the numbers.
Is that 17.13 discount because it's Evergy's position that customers who take service at primary should pay rates that are designed to recover costs associated with the secondary distribution system?
I think that's a misstatement of our position, Judge, but if you can answer it.
Yeah, I would not say that. I mean, your questions are assigning very specific costs to pricing that historically has not been linked to cost. Our pricing that we establish on our tariff sheets are not aligned specifically to cost. They're informed by cost studies. But at the end of the day, there is a disconnect between the costs that we incur and the pricing that we put on our tariff sheets. And I know you're trying to make relationships, and generally those relationships are there for the purpose maybe of clarifying a cost, but I would hesitate to ever say that they are perfectly aligned because of the rate-making process and the way that we go about assigning the revenue requirements to these items. So I could only offer in generalities what these costs should align to.
Okay, so you can't speak to the 17% different?
As being specific to any cost, correct.
Okay.
I would not offer that. I would say that it's the intention that the facilities charge is covering those costs of local facilities for that customer. But the rate-making process, the way we settle cases, apply revenue requirements, will serve to break that relationship over time.
Okay, thank you. Now I've been referencing the MGS code specifically at Evergy, Missouri Metro for these examples. But as we said earlier, Evergy West does not have a comparable MGS class or MGS rate codes, correct?
Correct.
And the large power service classes at West do not have an all-electric subschedule, do they?
Correct.
Okay. And the small general service classes at West don't have demand charges, is that correct?
I think that is correct. I only pause because the small general service class is the most noisy of all of the classes, and we have differences across all 4 of our jurisdictions, but I would accept that.
Okay, but other than the main distinctions that I've just identified, the general relationship between Evergy Metro's medium general service would be more or less consistent with the commercial and industrial classes for Metro and West. Would that be fair to say?
Yes.
Thank you. All right, moving to a new subject.
Just hearing your comment that you're moving to a new subject, I would interject that it's been about 2 hours since we came back for lunch. I am looking for a breaking point to give everybody in the room a chance to stretch their legs, and then we'll be coming back. Is this a good stopping point for you?
Yes, this would be great. Thank you.
Excellent. Let's take a recess. Let's come back at 3:05. 3:05, we are off the record. All right, let's go back on the record, the time of recess having expired. Before we get started, Ms. Lange, if you could search for, on your desk, the tariff sheets, Exhibit 212. Just throw a paper copy at me sometime in the next couple hours.
Here, yeah. Yeah, go
And
ahead give 'em that.
speaking of the next couple hours, let's talk about our end time for today. I am thinking about 5-ish. Everyone, lots of people here in the building participating as witnesses, as counsel, and as all types of other stakeholders here have things to do in the evening. They have kids that have schedules. So I am wanting to make sure and be respectful of that. We also have a 2-day hearing, and I want to make sure that the parties get the opportunity to put all of their witnesses on. Any objections to ending at or around 5 o'clock? I'll revisit that around 5 o'clock. Okay, let's go ahead and get started. We are at cross-examination of staff of Evergy witness Lutz. Following this will be commissioner and bench questions, recross, and then redirect. Staff, your witness.
Thank you. Judge, during the break, I handed a copy to you and to Mr. Lutz of the report and order that was issued in case number ER 2022-0337. I referenced that earlier. Mr. Lutz, in your direct testimony at page 23, you reference this page 48 of this order. Do you agree with that statement?
Yes.
Okay. On page 23 of this report and order, there's a heading titled Decision. And if you could look at that paragraph, which continues on to page 24.
Yes.
So that language discusses the commission's finding in that case, that, there's no more, that the company and staff CCOS studies were not suitable for allocating Ameren, Missouri's revenue requirement. And it states the commission finds none of the parties' CCOSs suitable for setting rates that are just and reasonable in this rate case. The commission finds staff's concerns about Ameren, Missouri's CCOSs credible. The commission finds staff CCOS insufficient for allocating class revenue responsibilities because staff was unable to obtain the necessary information to complete more than an interim step towards its goal of rate modernization. Do you see that paragraph?
I do see that paragraph.
Okay. I would ask the commission to go ahead and take notice of the report and order, or at the very least of the pages referenced here and the page that is referenced in Mr. Lutz's testimony.
The commission's preference has not been to simply take note of it. It has been to make sure that it has an exhibit number. And although the commission has the power to just recognize and take note of this report and order, I would like to go ahead and ask for objections, just to cover some bases. I have Exhibit 215 as the next staff number. Staff, is it
Your
okay
Honor,
with you?
We haven't seen the exhibit.
I just got it.
Oh, sorry.
And I'm sorry, you're,
Counsel, is this different than what's referenced on page 23 of Sir rebuttal testimony of Ms. Lange? Or, I'm sorry, of Brad Lutz, where he quotes from ER 2022-0337.
yes, this is a different section than what was referenced, and Mr. Lutz does have the full document that includes the portion that he referenced.
Okay, well,
Your Honor, while we're in the process of this, based on your previous statement, are you anticipating the document to be filed as an exhibit at some point? You've given it a number, are you?
If I don't get any objections, if it's admitted onto the record, then yes, it would be an exhibit. Yes, it would be filed in EFIS in total, if that is the motion that passes.
Thank you.
And Judge, I don't have an objection if you want to make it an exhibit or just take notice, whatever is your practice today.
The exhibit number, only because taking notice can be hard to cite.
And that's fine. We can offer it as an exhibit. So that would be 215.
Exhibit 215, you heard the motion by staff. Are the objections? Hearing none, so admitted. 215 is the report and order from 0337.
Thank you. And Mr. Lutz, looking at your Sir rebuttal testimony, page 4.
I'm there.
You state that since all of those prior cases were examined by the commission and the rates were found to be just and reasonable, I disagree with the assertion that past approaches were flawed or based on unsubstantiated assumptions, or that provisions of the data requested by staff will now correct some historic error. Is that correct?
That is what I say, yes.
Okay. But you do agree that the portion of the order in ER 2022-0337 specifically references a data shortfall?
Judge, I'm going to object. I think that's talking about Ameren. It's not talking about Evergy at all.
However, Mr. Lutz did reference this order specifically in his testimony.
Not in that segment, but
However, taking a portion of an order out of context, you kind of assume upon yourself that the entirety of the order may be used to fulfill that context.
It does seem like we're getting a little far afield, but I'm going to allow it. What was the question? The question was, or I'm sorry, the objection was that this was Ameren.
not relevant to this case.
Right, but your question, your underlying question was, does he acknowledge that a lack of data was cited in the Ameren case?
Correct. In light of his statement in his testimony referencing that since prior cases were examined by the commission and the rates were found to be just and reasonable, I disagree that past approaches were flawed or based on unsubstantiated assumptions.
I don't hear an objection to the question, and I'll allow it. Go ahead.
Okay, I agree that the statement was made about the data, but I would go on to say at the end of page 23 that the commission went ahead and took steps to allocate the, the agreement allocated the customer classes on an equal percentage basis. So an alternate outcome was achieved and found to be acceptable to the commission, resulting in just and reasonable rates. So just because the data was insufficient didn't impede the commission in exercising its role in putting just and reasonable rates together. And so back to my testimony, that's what I'm saying, is that the commission in its authority has looked at the record, looked at everything, and despite data issues or questions, they can still establish just and reasonable rates without having perfect cost data, studies, whatever. They exercise their authority and analyze it in a different context, if you will, but it's still a just and reasonable rate. So for it to be asserted that these are unsubstantiated is, I think, a bit of a reach.
So, but Mr. Lutz, when you say everything, that includes all of the data that's provided by all of the parties, including staff, correct?
Correct. Everybody will have a
Thank
different
you.
opinion that they bring to the commission for their consideration.
Thank you. That is all I have on that matter. If it were entirely up to Evergy, when do you anticipate that Evergy would do the programming to be able to add AMI metered customer usage by rate code to know how much energy customers on what's currently identified as RTOU2 or the summer peak time-based rate plan were using at 6 p.m. in July versus how much energy customers on the RPKA or default time-based rate plan might use in that same hour.
I'm going to ask you to ask that one more time.
That is fine, I can do that. When do you anticipate that Evergy would do the programming that would allow it to be able to determine, based on AMI metered customer usage by rate code, to know how much energy a customer on the summer peak time-based rate plan and the default time-based rate plan would have used for the same hour, say at 6 p.m. in the middle of July?
Okay, there's a lot there. For me to answer that question, I would have to establish or describe that the hours are not important to the proof of revenue process. That when we are establishing the revenue requirement and apportioning it to the customers, we are looking at the billing determinants for those respective rate codes. So how many kilowatt hours occurred in the peak, how many in the off-peak, how many in the super off-peak. And those are multiplied times the rate to generate the revenue that design would produce. It does not require the hour within that.
So Evergy would not anticipate looking at that?
There would have to be a need for identifying the hour. Now, up to this point in our experience doing time of use rates, the hour detail is most beneficial when trying to determine the periods, if there's a need for the period to move around. But to just exercise the application of a revenue requirement within a rate case, the hourly data is not needed.
Okay.
So I would say we would probably not estimate a time for that programming.
Okay, and when you say period, you mean the periods of different rates based on time of use?
Correct,
Okay.
correct.
Given that, in that same vein, do you think that Evergy would do the programming to be able to determine how many customers were on summer peak time-based rate on that date versus how many were on the default time-based rate to be able to compare usage per customer?
And is the question again about programming?
Yes. But given strictly based on Evergy's timeline, not including staff's asks.
I don't know that I can offer when we would do programming to achieve those details.
Does entirely based on Evergy's expectations, do you think you would ever look at hourly usage data?
Certainly, certainly. I mean, I think like I described a moment ago, there are times when it's necessary to go below the billing determinants to get more information. But at this point, and in the context of the residential rates, those are just now freshly deployed. We aren't looking to change those hourly periods today.
And that wouldn't be by rate code if you were looking at that.
Well, by then, yes, I would say at some point in the future, there could be a need to look at hourly usage by rate code. In today's rate making and what we're doing at the moment, class data is more than sufficient to achieve a outcome in a rate case.
Okay, and you don't know when that would be. It would be based on as yet undetermined
Right.
factors.
There's a lot of variables as far as when a case might occur, or when changes might be needed.
Okay. Can you tell me what the low-end ballpark range would be to build a mile of a new primary voltage line overhead?
Nope.
Okay. Do you know who at the company would be able to answer that question?
Well, we attempted to try to learn this through the discovery process and our other interactions with staff. And the answer that I got from the people I consulted was there are too many variables to determine. That, you know, if you're talking about urban, if you're talking about rural, there's a lot of variables that could come into play that could greatly affect that number.
But Evergy might be able to, with a collaborative effort, determine alternatives based on a narrowed definition of that data?
Certainly, but every assumption then potentially limits the result or influences the result. I mean, that's part of the reason in our cost of service studies you see the allocation methods that are there, is that there just isn't a precise, clean way in many of these contexts to assign the costs. So allocations are used as a proxy to get those costs to the respective classes.
Okay. And would the answer be the same for the miles of primary overhead line and primary underground line?
Yes.
Okay. Do you think that a study could be done to look at the cost of the secondary system versus the primary system, and then any other voltage distinctions that appear in Evergy's tariffs, using either the relative marginal cost or the relative embedded cost?
Again, depending on your definition of study, I would offer that there is a level of that occurs within our normal cost of service process, and that efforts could be made to extend that to provide even more granularity within that cost of service data. So depending again on how you qualify what is a study, some of that exists today.
Do you know if that's by relative marginal cost or relative embedded cost?
Generally, embedded cost is what you're going to see. The company has loadings, for example, that it has to account for in its pricing of those. So, yeah, it's generally not a marginal cost.
Okay. And do you know if that's by primary or if it's more specifically like 34 kilovolts versus 14 kilovolts?
No, I mean, in that case, there's the real potential you'll start commingling voltages. What we'll do is we seek to provide service to a customer or a group of customers with a particular project. It's not done on a voltage basis. It's done to achieve a service. We're trying to provide energy. So it could include primary, it could include secondary, could include higher voltages that might happen to be on the same pole. There's too many variables concerning how we execute the construction of this distribution grid to assign those costs precisely to a given voltage or to a rate code.
Okay. And then going back to the customer charges that we were referencing that would vary by annual demand, do you have someone that would be able to reference the kind of data that you have about costs for metering a 500 kilowatt customer versus a 50 kilowatt customer, or say a 1,500 kilowatt customer?
Yeah, the data is available. Oftentimes in our cost of service studies, there is some level of that data available. But
Okay. And so there would be somebody that we could work with on that.
right, but I caution that you can't be certain that you're going to be able to give it in a by voltage or by rate code form. That's the factor that really changes things for us.
Would that be simpler if we didn't ask for it by rate code?
Yeah, I mean, yes. I mean, the way we do things now are generally at the jurisdictional level and then allocated to classes. If something can be done at that level, it links with data that's already available in the class cost of service processes, and it avoids a lot of the problems with mass property, say like poles, things that aren't accounted for uniquely in our system accounting, like the testimony of Sean Riley referred to.
So also limiting it to customer size as opposed to customer class would make it more possible?
Class is where I would prefer to start. that's where things are most normally divided in our cost analysis.
Okay, thank you. And then finally, I am going to ask Ms. Lange to hand out, there are, data requests, the responses that were provided to staff's data request 207 and 206.
Oh, you're good, thank you.
And if you could honestly just verify for me that this looks to be the appropriate questions that were asked in both 207 and 206, and Evergy's responses to such.
Yes, they are.
Okay, then I would go ahead and offer these two data requests into evidence. One concerns interval meter reading data, the other concerns customer count data. And that would be staff's exhibits 216 and 217. Did you not get 206? There should be a copy of each. I apologize. I can actually give you my copy in just a minute, if that will help. But I will offer those into evidence if you need me to provide more. Mr. Lutz has verified them. I have them identified as 207 being exhibit 216, but let me know if that's confusing.
Okay, I have the motion for the admission of exhibits 216, which is data request 206, and exhibit 217, which is data request 0207. You've heard the motion. Are there any objections? Both are so admitted. Go ahead.
Thank you. And then finally, Mr. Lutz, earlier, the council asked the Evergy witness, Ms. Dragoo, about the DR response to staff's 250.1 that was asked in the rate case, ER 2022-0129. And that, Evergy's response in that case was that no voltage or loss adjustments were applied to the hourly load by rate class data provided in response to DR 250A. The data provided represents the direct measurements on the customer meters. And Ms. Dragoo said that she would recommend you for an explanation of that.
Okay. Sorry, I was looking at these two, and then you asked me about a different one.
Which exhibit number? I'm sorry.
That was offered as 204,
Thank you.
and I believe that was received into evidence. Oh, I'm right. I think I'm right. Yeah. Okay, yeah, then it was offered as 205. Sorry, staff's numbers have also now gotten confused.
For the record, this would be staff DR 0250.1. Sorry.
Yes, that's what I have for exhibit 205, is DR 0250-1, or .1.
That is correct. That is what I'm referencing.
Okay, I think I've finally caught up.
Then that is actually all I have, is just to refer that to Mr. Lutz. I guess it was admitted? Okay. I apologize. I did not realize it was admitted. I just knew it was deferred to Mr. Lutz, and I wanted to ensure that it did get admitted.
Let's just do it one more time, just for giggles, make sure.
Okay, then I just wanted to offer 0250 identified as Exhibit 205.
Any objections to the admission of Exhibit 205? Hearing,
No objection, Judge.
hearing none, that's so admitted.
And that is it.
Okay, thank you. That takes care of cross-examination. Now we will go to commissioner questions. Are there any commissioner questions? Chairman Root.
Good afternoon.
Good afternoon.
How does it feel to be the guy?
Not great, if I'm honest.
Well, I'm going to pile onto that.
Feel free.
Okay. Badoom. What is the estimate of cost to provide provide line transformer cost and expenses by rate code?
What is it? In our operational perspective, I don't have an equivalent. This is more related to what has been asked for by staff. In our operations, that would be commingled with projects and other rate design or line extension work that we might be doing. So it's a reflection of staff's approach for answering questions about distribution cost.
Yeah, so that's what it would be used for, right? But you
Yeah.
don't have an estimate of
Oh, the actual number?
of the cost.
Sorry.
The cost to generate that or that information.
Oh, with respect to data set one, is that the context of the question?
Yeah.
Yes, the concern there is that much of the data that is being looked for example, transformer costs by rate code or something like that, is not present in our accounting systems or our work management systems to even offer. So it's not an attribute that we track operationally and cannot turn around and offer it as requested.
And would that data be valuable to anyone as a standalone, or is there other data it would need to be compiled with to be useful?
I think it would have to be compiled with other data to be useful.
Is that something that the company would find useful and needful in the future?
Only to the extent that there was concern about the current approaches used to recover costs or price those elements in our rates.
To your knowledge, has any other state adopted a similar methodology to what staff is generally proposing to use?
For data set one, no. And that was part of the purpose of seeking out help from Mr. Riley to make sure that we looked at that and looked for anything that might be out there. And his testimony, I believe, is that this is not done anywhere else.
Okay. To your knowledge, are there any NGOs or any other state PSCs advocating to adopt a similar methodology to what staff is proposing?
I have to be careful there because I know where the long view that I believe staff is attempting to achieve, and I spoke to that in my testimony. And I think there are commissions that have adopted those concepts, but I am not aware of those that have adopted distribution cost studies by rate code as exhibited in data set one.
Okay. So if I were to ask you Evergy's estimate of costs to provide primary distribution costs, secondary distribution costs by voltage, would you have the same answer as your first answer on the line transformer costs by rate code?
Well, what I would offer in the interim would be to go to our existing cost of service studies where we take that information by FERC account and allocate it to the classes. And that would be my first response, and seek to determine if that presentation of cost is adequate to your need. Because that is offered in every rate case where we do allocate those costs out. What's distinct is that staff is seeking to go beyond that and to try to look at the distribution costs in another way. And my testimony has been thus far that we're really not leveraging the data that we have before us in the current cost studies to inform our rates. And I would offer we should try to consider that first before going down a new path for yet another input on distribution costs.
So I had similar questions on all of the different data sets, and I guess I can just ask them, and you can either just, I'll just ask them and you can answer them, or just tell me if it's the same answer as the previous ones. So we did the line transform, we talked about primary and secondary distribution. What about like primary voltage service drop cost and expenses?
Similar. The only one that might give us any opportunity might be meter costs, because there is much more of a one-to-one relationship between metering and billing. And there could be some way to create linkages to rate code or other things for that one element of distribution cost, but it's not the significant item.
So if you could tie that to rate code, could you also do the meter cost by voltage?
For meter costs, that's the only one that there's any opportunity to do at those levels. The others are just not utilized in a way that would allow that association cleanly. For the others, no matter what you do, you would still have to allocate in some way because of the shared nature of distribution facilities.
Judge, I think that's all I have.
Thank you. And Commissioner Holzman.
Good afternoon.
Good afternoon.
First off, I want to thank you on the testimony. I really liked the color-coded chart. I think that visually it kind of helps frame the issues that we're dealing with here today. So based on that, you had 7 in green, 3 in yellow, and 3 in red. And my first question is, the 7 in green, are we at a place where the company is willing and ready and able to provide that data?
Yeah, and let me clarify there if I may. There are 2 columns. There's the availability and then the deliverability. And in many cases, the data is there. It's just a matter of how do we get it out? How do we package it? How do we make it in such a way that it's repeatable, usable? If staff comes back 6 months from now and wants something different, we need it to be the same. And so there are controls that we have to put in place, repositories. So that deliverability column is really the crux of our concerns. In most cases, the data is available.
And would you then put a qualified time frame on, if it's repeatable, how quickly can you produce it?
Right, right.
On the 3 yellows, is this, and again, I know you separating the 2 columns, is this something you feel positively about that you're going to be able to accomplish the request?
I think so. The one I might draw caution to is number 9, the coincident peak demand and reactive demand. I hope that we have an opportunity to look at that much closer in a rate proceeding to see what's applicable to Evergy. I know there were things that happened at Ameren that led a certain way, but I think those might have been driven by other things that were specific to Ameren. But other than 9, I think on number 6, for example, we offered that is, it says from time to time the commission may designate certain items. So on that one, it's just a little bit open-ended. So yes, I agree with you, but it's really dependent on the context of the specific ask. The third one, the last one, is intervals. And the issue around intervals is that we have those in our meter data management system, the MDM system. You may hear it referenced. But it's not something that we use for other purposes. So would have to make sure that we can get those intervals out and delivered. So there would be some work on that number 4.
Okay. And then on the 3 red, we heard from the previous testimony that
Yeah.
one, because of its cost, $80 to $100 million was going to be almost an impossible lift.
Yeah.
The other 2, was it 4? Or I'm sorry,
5
and 8.
and 8, yes.
Are either one of those 2 is the company's position that you are unable or not going to be able to produce that information?
Correct.
Regardless of, what we come up with here?
1 and 8 are related. 5, I think Julie Dragoo spoke to that there was new information about the nature of these adjustments that are talked about in 5. I would say if we did this today, it would probably be yellow for number 5.
Number 5, okay.
Yes.
Okay, well, that helps. The only other question I have is, on the 7 greens, I know 2 of them are retention, so, that's not really asking to produce anything. It's more just, saying retain information. Why does it take commission action to get that information to staff? What's the company's response to why it's required this to get that information?
Right. And it really boils down to the fact that these requests are moving beyond what we do normally. And they're asking for things maybe in a nuanced way or in such a way that we've got to step aside and do other work specific just for staff to deliver this information. And because in some cases, it's maybe getting down into levels of detail that require us to go back and redesign many of our upstream processes to get it there. It just started to test the bounds of how far do we go? What's reasonable for us to do and provide? I mean,
Do you feel like this hearing has provided an idea of what the commission or what staff is asking for, what is reasonable?
well, I mean, I feel like I understand what staff is needing. And I hope what is being heard is that we have some limitations to what we're able to do easily. There's going to be cost and effort regarding some of these items. So what I'm looking for, what I hope is that the commission can offer some structure around how do we bridge that? How do we resolve that difference and determine what's right and needed for our customers, to make sure that they have just and reasonable rates.
Okay, so that was my last question, but I just thought of another
Oh,
one.
that's fine.
Assuming that we ordered you to do all of these, do you believe that these costs would be in rate base? I mean, is this something where the ratepayers would ultimately bear the expense in a rate case for this data?
Yes, because a number of these will be incremental. I mean, some of these we could probably do within our existing staffing, existing efforts, some of the smaller ones maybe. But for example, on 1, if you said we had to do number 1, we're gonna have to start over in a lot of respects as far as how we do our basic processes, how we do our basic accounting. We're gonna have to lift up the house and change out all of the foundation before we can drop the house down and renovate. So, yeah, that would be a big lift, and it would have to, that kind of money is significant to the company.
Okay.
Yes.
All right. Thank you for your testimony.
You
Thank
bet.
Judge.
Commissioner Hahn?
Thank you, Judge. Appreciate it. Hi, Mr. Lutz.
Good afternoon.
Good afternoon. Just a few different questions on a couple different topics. I'm really interested in your view, and I've read some of your testimony, of the why, kind of the goal behind the data. So from your view, and your view of what staff's goals are with regard to the data, what do you think the ultimate end goal is the data? If you were to be able to produce the data to give to staff, what do you think the ultimate goal of staff is, with using that data?
Yeah, I believe staff has a vision for where they want the rate designs of Evergy to go, and that these data elements will help them get there.
And do you think that in order to get to staff's goals, that all of this data needs to be provided, or can certain components or others be provided to satisfy those goals?
I think, well, let me speak to the differentiations we've offered thus far. The cost data under data set 1 and 8, the part of 8 that's associated with it, that is just, there's got to be a different way to do that. I think that the way the staff has come at that is just a way that is not workable within our traditional accounting methods. There's going to have to be something different. I think we've all acknowledged that the ones related to customer data, mainly 2, 3, and 4, there's a lot of opportunity there. It's just really a question of how do we deliver it. A lot of the details about that. And then finally, number 9 kind of stands out again because that really hasn't been litigated for Evergy. To know whether coincident peak demands or reactive demand elements are needed for Evergy is an open question to me. So I think that there are other things that need to be addressed there before we were to address your question on that one.
Thank you. In your original testimony, you did reference other utilities in the data that they provide. Specifically, you mentioned Liberty and Ameren. Can you speak a little bit more about that? Do you know if they provide this exact data? And I'll ensure to ask staff the same. But what's your knowledge level about what they provide?
Right. We've tried very hard to stay abreast of this. I know the commission's aware we've not been able to intervene or participate in some of those cases, and they weren't able to participate in this one. So we've had to rely on other paths to try to stay abreast of what's going on. But the sense that I get is that not all of us have been subjected to these very same 9 questions. That most of the parties or other utilities have received variations. So you might acknowledge themes that maybe are crossing the utilities, but there's difference in what is being asked of the utilities. And then also there's difference in the way the utilities have executed their, for example, rollout of their time of use rates that maybe have afforded them the ability to maybe have more data sooner, or variations like that are utility specific that need to be taken into account. But I think I have a sense of where the utilities are on those matters. And in my assessment, we are everywhere across the board. That some are starting to provide data or similar data. Others have not, and have not taken any steps yet, maybe other than a commitment to do so. So I think it's ripe now for us to understand what is acceptable for rate design support going forward.
Thank you. Also, in a combination of your testimony, your rebuttal, and staff's testimony, it seems that I'm going to summarize here, so bear with me. I'm going to say a miscommunication or lack of communication about, what is requested, what is available, what the company is able or willing to provide. And I think, again, this is my own summation, but staff has thought that the responses from the company have been non-responsive, and that's not been the company's position.
Correct.
So can you please further explain what communications, maybe perhaps outside of the testimony, that you've had to try to fulfill staff's request?
Right. Yeah, I admittedly was very troubled by accusations of lack of good faith. Have been made by multiple parties against the company. I disagree with that. I understand the frustration of not being able to be given what you asked, but I don't know that that immediately equates to a lack of good faith effort. Many of the things that you've read about in testimony, like for example in Julie's testimony about how she performed the estimates, are the very same steps I have to go through to get data out of our own systems. That shirt sizing exercise she talked about, I have to go through that too. I have to go through prioritizations. I have to go through all of those same hoops. And so in executing our estimates here, it was very aligned with what we have to do normally. And so although maybe people misunderstood our efforts, misunderstood what we offered in providing ranges and color codes and different things, this was a good faith effort to try to quantify what is a very difficult ask. Having an advanced system does not equate to an easy button for everything. We might see it in our own lives where, you buy a car and it's got all kinds of sensors and new things on it, and it makes your life a little bit easier, but in a lot of ways it's not. There's complexities now. Nobody works on their car anymore, for example. But my point is that we've gotten to this point through a lot of small steps that have turned into something maybe big or frustrating for us all. It probably started small as data requests, and within a 20-day period, an answer was given, and it escalates to a point where it's now an issue in a case. It becomes a settlement. It moves out of settlement into this, and it's encumbered with all of the formalities of the procedure, and it gets harder to just talk. So I think that's a big attribute of it that maybe was not completely communicated in my testimony, but I did want to signal it, and I think I spoke to it. And I'll admit, I think we have trust issues between us. Maybe it's been said as much in other testimonies, and I know that we've got to collectively get over that and work through it. But that's, I think, part of where the commission comes in is to help moderate, in a sense, give us some guidelines, give us some boundaries that we can interact within, and maybe start to repair some of those issues and find some level of collaboration going forward.
Thank you, Mr. Lutz. I appreciate your honesty and frankness, and I'll make sure to take that into consideration. Thank you so much.
You bet.
Are there any other commissioner questions? All right, hearing none, the judge does have a few questions. I'd like to pick up where Commissioner Hahn was talking about the meeting between staff and the company. Can you give me an estimate about how many times Evergy met with staff between the end of that rate case, so September 2022 through June of 2023?
Yeah, I would say that the meetings between staff primarily happened before the stipulation, I think, subject to check, that we tried to meet during the case, during the discovery phases, maybe even during the settlement phases of the rate case, to determine if there was some way we could find some common ground on the data requests. After the stipulation was set, I don't believe there were any meetings with staff after that stipulation was set. At that point, we went to our corners. The company attempted to find out if it could produce the data by July 1. And when it didn't, we filed the order to, or the motion to open this docket on the EO. And since that time, it's been largely in the formalities of the EO docket.
Staff will agree with that statement if that helps.
No, you can't testify. But thank you.
Well, and I will say, I mean, the company has tried to stay engaged in other ways. We've joined with the non-residential workshop out of the Ameren case and have heard from staff and how they've interacted to learn more about the data that's needed. We did have a couple of meetings. One that was out of our stipulation, we were required to meet. We had a second, and then schedules just kind of got in the way of us doing any more. But I would say we've probably been together 4 times in other venues, not specific to these data needs, where we've interacted about data and about things to where I feel like I have greater understanding of some of the future potential. But in a sense, you know, we're tied to these 9. You know, when the EO case was opened and the stipulation that ahead of it, it wedded us to these 9 data requests in some sense. I think I said it before earlier, our answer is probably not these 9. It's something else that we'll ultimately get to common ground on. It might be informed by these 9, but it's probably not these 9.
Since that settlement was agreed to, has Evergy hired any employees to look into coordinating this?
To executing this any further? No, because where we were in our mindset is that once we were unable to meet the deadline, then it became a question of, is it worth doing? The language of the stipulation said that we would bring forward our reasons why we couldn't do it for consideration. And so in our minds, we needed feedback to know if we should continue, and so we didn't expend those resources.
Did you consult any third-party consultants or vendors, anyone not directly employed by Evergy for an estimate?
Not in a formal sense. We interact with a number of vendors just on a day-to-day basis and would take advantage of, you know, informal communications with them, you know, avoiding cost, you know. But if you had them in a meeting for some other reason, we might ask. But nothing that I could offer as evidence or anything formal.
Would any of those third parties be involved in the requests?
They could, yes. One of the specific parties I won't name, but you know they have role elsewhere in our corporation for supporting our systems.
In a normal course of business, would Evergy be able to get an estimate from a third party for free?
Well, what we would get would be some kind of a time and materials estimate. Based on what I understand and what our experiences with projects of this scope, without some level of specific business requirements to constrain the scope, no vendor will commit to a number. They would give us a time and materials, and they'd say, we'll stay here as long as it takes to get it done. And so, no, I don't think we would get an estimate that would constrain someone, but we would get a billing rate for their support.
I want to find out, at what point will they charge you? Is your relationship with a third-party vendor such that you can say, hey, vendor, can you write me up a proposal to coordinate this database and this thing and that thing? And at that point, are they going to say, yes, and you need to give me $500 to do all that math?
Right, yeah, anything that's going to be of any detail will require time of the company, time maybe even of staff to help frame the scope. And if you note in some of our, like let's use data set 1, for example, in the fourth column, we said that there was a $5 to $10 million design phase. Do you see that in there? That's what that might refer to, is that it could take a significant contribution of effort to get just a design stood up.
So let me make sure that the record is clear and that I am clear in my mind. When I am referencing an estimate, I'm thinking as a homeowner, I call up local repair guy
Yeah.
and they come out and usually provide a free estimate. If it's an expensive estimate that's going to take some time to review, I might, as a residential homeowner, expect that there could be a cost. So
Yes.
when we're talking about Evergy, we're not talking about a 1 or 2 page estimate. We're talking about a design contract.
In a sense, to use your analogy a little bit further, what we're giving here is like when you called that service person for help, and you say my furnace is not running. Let's just say that's your scenario. There's a usual range of costs to get a furnace going, and that's the kind of estimate that you're likely to get from that person. It'll be between $100 and $500. I can come out and take care of you this weekend. But when I get there and I open up the cover and I find out that there's 9 or 10 other things, all of a sudden it's $2,000, $3,000, $5,000. That's the kind of thing that we're trying to deal with here. We've given you the first estimate, the range that gets us there, but as we go through the details, and for example, like today we heard about the potential for weekly data. Another aspect that came up in the data requests was a aspect of by billing cycle. Those are two new contexts which aren't unreasonable, but they aren't part of what we've considered thus far in these data requests or data set estimates. It's natural that as you start to look at this data and start to get into it, you see other things or other presentations that might be more advantageous. Just like that service person that takes the cover off your furnace and sees that there's now 2 other parts that need to be replaced, that expands the scope. And that's what we would be dealing with here, is trying to deal with that updated scope as we execute on trying to provide these data.
Has Evergy had meetings with staff to discuss alternatives? And I mean alternative data, alternative methods?
No, not really. Again, that falls on me. I mean, in a lot of respects, I could pick up the phone. Admittedly, the context of the case has given me some reservation about engaging on those alternatives, instead wanting to see out the procedure and see if there's guidance that we can get from the commission. So no, to answer your question.
Did the company's implementation of AMI require new configurations and customization of its utility computer software?
Some, I mean, yes, but if you remember, we were replacing a automated meter reading system with that AMI. So it was not like a revolutionary change. It was just an upgrade of sorts, if you will. We already were using a system for much of those same functionality. In these data sets, especially with data set 1, that one is entirely different. It's unique in and of itself. It would not be like an upgrade per se. So, back to your original point, how do I answer that? Well, maybe I'll just stop there.
I asked Ms. Dragoo about this, and I'm going to pass that on to you.
Yes.
Besides capital investments or maintenance expenses, are there any other type of cost or expenses tracked by voltage or rate class?
For our plant costs, capital or O&M, none are tracked at voltage or by rate class.
Regional transmission organization fees?
No.
Okay.
A little color on that, what we would tend to do would be to track them based on our corporate jurisdictions, and then they would be allocated to classes through the cost of service study. And that's where they would then, could be available to inform rate making. But it's an allocation based on some other allocation method, not a direct assignment to rate code or voltage.
Last question I have, and this is one I have heard quite a bit in my discussions. If you're not able to access the data that you are keeping on these different systems, how does Evergy know that it's recouping the appropriate revenue?
Yeah, well, to begin with, much of the data that we're talking about is not necessary to exercise that.
That's what I want you to answer. Can you just give me some more detail on that?
Right, right. So at its very basics, what we do is we have a revenue requirement that we have to apportion across billing determinants. It's a phrase, proof of revenue is what we often call it. And so we total up all of our kilowatt hour sales, all of our KW demand charges, all of our customer charges, and we have all of those determinants that we've identified. And the revenue requirement is applied across those, such that the determinant times the price produces a revenue. And the sum of those revenues is equal to our revenue requirement. So all we need to do the revenue requirement is the determinants and a price. We don't need a lot of that extra data that's not associated with a tariff determinant. Like an hourly load is informative, but it's not necessary for rate making.
Sorry, I'm going to
Yeah,
have one
go
follow-up.
ahead, go ahead.
Is it because they are grouped together when you produce the final calculation?
Right, when the billing determinants are totaled, it's done by, say, a peak period that reflects 4 hours, but it's one number. So we aren't interested in what's from 4 to 5. We've totaled everything between 4 to 8, and it's one number, and it's times one price, and that equals one revenue that gets totaled to give us our revenue requirement.
I'm hoping to save you from being recalled, and I'm just going to
Oh,
add.
I'm here, don't worry, don't worry.
Okay, never mind. I'm going to quit while I'm ahead.
Yeah, I'm here.
Okay, let's stop there. The judge doesn't have any more questions. I'm going to give the commissioners one more go just in case. Okay, let's go to, oh, yes, Commissioner Hahn, please go ahead.
Sorry, one more.
No, you're good.
Staff has stated in their testimony that going forward, they need this data for future rate-making purposes. Based upon the testimony that you just gave, do you agree with that?
The important distinction is they need it to support their proposal for that rate making. Our proposal is different. And that's where kind of the pinch is a little bit where we need the commission to step in. What's the company's obligation to support the staff's independent and different proposal when it's costly for us to do so?
Thank you for the clarification.
And Commissioner Coleman.
Mr. Lutz, good morning, good afternoon.
Good afternoon.
Evening, good year.
Yes.
So make sure I understand this. So you're saying that staff is asking for something that you all have, that you can provide, but it's very costly to you. And you're saying that that concern about the cost is even if what staff is asking for is to work on your cases.
Now, let me be careful. There are two aspects to the data being available. The data exists, but we also have to have a way to make sure the data gets out and gets presented in a way that's usable, repeatable, data quality. You know, you can do things that are just quick and easy, but sometimes you have to go through a lot more to get a robust, reliable process stood up. So in most cases, the data is present, but it's not deliverable, and we would have to go through those efforts to make it deliverable. So I want to make sure that I'm clear with that distinction. But what we want to support staff, and if we had the data that they're asking for, we would give it to them immediately. That's not the question. For us, it's now that we're starting to see a differentiation in the way we approach rate design. Instead of us kind of working along the same path, we're presenting two competing proposals. What's our obligation to support their data needs for that independent view? Because it's starting to become costly is part of the equation here. So does that answer your question?
But is that view to make a determination regarding Evergy? Or is your concern that this is a template that will be used for a variety of different IOUs?
No, I don't think I have a concern either way on that, whether it be limited to Evergy or used for statewide purposes. I don't think I have a distinction there at all.
Okay, thank you. Thank
You bet.
Judge.
Okay. That will end the questioning. We'll go back to recross and then redirect. Let me check my handy cheat sheet. And we'll go to Mr. Opitz.
No, thank you, Judge.
Public counsel.
Hopefully brief. Good evening.
Good evening.
It's been, 4 hours? It's a marathon.
All good.
Really quick, you had a question, a conversation with Commissioner Holzman about your schedule, BDL 1. You have that in
Yes.
front of you?
Yeah, go ahead.
And you were kind of talking about the different color codings, and number 5 was discussed. And I think you said something along the lines, correct me if I'm wrong, that if I went back and looked at it today, 5 might have been a yellow. And I think that Mr. Gu said something kind of similar in
She
her
did.
testimony. So I believe that all the numbers in that column are public, right? We've established that now?
Yes.
The costs? Super. Would that potentially change the cost listed there?
Yeah, at this point, I think the testimony of Mr. Gu is that it's to the low number,
Okay.
is where we're at the moment.
So that 3.75 to 30 million range, you're talking about the much lower range is probably closer to what that would actually cost. Now
Correct.
you have a better understanding.
Correct.
Super. And then on the talk on 9,
Yes.
that was the coincident peak demand, right?
Yes.
Yeah.
Yes.
So if I understand your position correctly, it kind of boils down generally to the idea that you don't feel like this has been litigated, and you'd rather have this litigated first before committing to coming up with what it would look like, right?
In a sense, in the few interactions that we've had, especially in, I guess I can reference industrials that have participated, there's been reservations that they too are not sure that this is what they would like. And so we listen and would like to have some due process within a rate case where all of the parties in the Evergy jurisdiction can speak to that need, whether that's necessary.
So hypothetically for a moment, if in a rate case or two from now, the question of whether or not a coincident peak demand should be implemented comes up,
Yes.
and the commissioners ask you the simple question, well, can you calculate what that CPD would look like? Is that something that you can answer now? Will you be able to answer what a CPD actually will look like if in a future case it becomes litigated?
The big answer is yes. However, I'd have to quantify, there are a lot of details about making data like that available. In the experiences that I've had with the Ameren non-residential workshop, they've gone through a lot of effort to compile and put together data to support that discussion. So I would imagine we would have to go through that same exercise at minimum to make it available. So if it depends on if that's asked in a data request in a rate case, it's not something we could do in 20 days and satisfy a data request, for example. But if it were,
No,
If-
I get
okay.
where you're going.
yeah,
How would that work then in a rate case? Would you wait until after the commission ruled on it to then try and calculate what the rate would look like?
well, yeah, in a way, because what you're doing here is you're basically changing the whole basis of the demand pricing. You're going away from a non-coincident to a coincident view. It's going to change the determinants. You can approximate some things for this to explore the policy of the change. And once that's established, then you can go ahead and make a proposal under it.
Okay, but then if I understand it correctly, you don't really think it'd be possible to come up with what a CPD would actually look like numerically before the commission went down the path of saying, we want one, or we want to consider it?
Right, because, and let me give a little flavor, and this is going to preview what you'll see in my testimony coming up for the Missouri West case. In the Missouri West jurisdiction, for example, we have what's called annual-based demand that's part of that rate structure. It's a seasonal pricing structure. That would complicate the conversion to a coincident peak basis. So in that jurisdiction alone, I would think there needs to be some steps to address the annual base demand element before we piled on and tried to address coincident peak pricing as an alternative.
So another line of question that you had, and I believe this was a conversation you were having with Commissioner Hahn, was kind of discussing, I want to make sure I'm close enough to the microphone, working with staff to try and resolve some of these. And
Right.
I don't want to, I'm going to try and paraphrase you. You kind of said, maybe I could have picked up the phone, but we wanted some guidance. Is that kind of the idea?
Yeah, at
And
this point.
If the commission were to say, like, our guidance is that we want you to develop this, but maybe not at these prices, so please go work with staff, is that something you could get and take away from this and try and work towards finding a solution here?
Certainly. I mean, if nothing else, I want everyone to take away from this, the company is not trying to be obstructionist. I know you brought up the idea that we're not acting in good faith. I disagree with that. I mean, we can have differences of opinion. We can maybe even tell you no, but that doesn't mean we're not trying. And we will try. We will commit to coming together and trying to find a way. I understand what staff is trying to move towards. It just is a different outcome than what we've contemplated in our consideration of rate modernization.
I understand. Thank you very much. Give me 1 second. No further questions? Thank you.
And staff?
Thank you. Also brief. Commissioner Holzman was asking you about provisions 1 and 8,
Yes.
in regards to the company's chart that it produced.
Yes.
Are you aware that staff in rebuttal in its position statement stated that it was open to alternatives that would cost less than what the company proposed?
Yes, I'm aware of that.
Okay. Were you aware that staff asked about taking samples at in-field installations?
Yes.
Okay. Commissioner Hahn asked you about the Ameren and Liberty data, but you did just state to Mr. Kleiser that Evergy is participating in Ameren's rate modernization workshop?
We're observing, yes. Participation might be strong.
Okay. You're part of the docket per se. You've been at meetings?
No, well, I've been to the meetings. We weren't allowed to participate in the case itself, but we've been invited to the workshop.
Okay. When you say you weren't allowed to participate, were you denied in some manner?
I think we attempted to intervene in the cases. And
Judge, if I could clarify, we asked, Liberty and Ameren asked to participate in this docket, which is an EO docket, and they were denied. Staff opposed that. They were denied. In the working docket that they're referencing in the Ameren case, it is a public working docket, and anyone can participate, and Mr. Lutz has been attending that. That's the difference. It's a nuance, but that's the distinction.
And were we allowed in the Ameren rate case?
Your
Oh,
Honor,
yeah.
at this point, I think now that Mr. Fisher is testifying?
I'm sorry, Judge, if I was trying to clarify the situation.
And I apologize if I was misstating.
That's just what I'm trying to understand. Do you know if Evergy's motion to intervene has been denied in any recent case?
Now I'm uncertain.
Okay. We'll carry on. Judge Hatcher was asking you about meeting with staff. You mentioned that there were 4 interactions that occurred outside of this docket between Evergy and staff. Can you tell me, were all of those after July of 2023?
Which would have been the date of the EO docket. Yes,
The date that was referenced in the
Yes.
stipulation that Evergy said it would provide this information to staff?
I believe that's true.
Okay, thank you. And then Commissioner Hahn, in the second round of questioning, mentioned, was asking you more about the way that Evergy sets its rates. Would it be your testimony then that Evergy does not need the hourly loads by rate code in order to weather normalize its residential rate plans for revenue and billing determinants?
Well, I think in some respects, I would mirror what staff said in their data request to us on that matter, that we're not certain. Historically, I would say no, but I think there could be a need, but at this point, we've not seen it. That hourly loads for weather normalization, there's not a clear need that I see.
Okay, Evergy hasn't identified one at this stage.
Right. I mean, if you're thinking about weather, you're looking at 30-year periods for weather. I mean, it's usually big data. It's not hours. Weather by hour is, I don't know, I'm still trying to come to my opinion. Admittedly, that's not my area of witness. Usually we have other company experts that would speak to that. But as a interested party, I don't see a linkage to hourly.
Okay, thank you. That's all I have.
And redirect.
Well, where to begin? Let's try to get done before the end night here, end time. Let's go back to, I guess, the meetings that Judge Hatcher asked you about since
Yes.
the rate case. Did you also have meetings with staff regarding rate modernization since that last rate case?
Yeah, that would have been 2 of those 4 that I mentioned.
What was the first one about?
The first one came out of the stipulation terms itself, where we had agreed to meet like around 180 days after the order, and that was the first meeting.
August the 9th, around that
I
time?
believe that's right, yes.
And did you have another meeting on August 28th where staff made a presentation?
Correct,
And that was about their rate design vision or proposals?
correct.
Just at a high level, can you explain to the commission maybe a difference in the 2 visions?
Yes. I alluded, or I spoke to it directly in some of my direct testimony. I believe that many of the aspects of the staff view have been informed by the Regulatory Assistance Project and some of their smart rate design guidance. And really what I believe it is moving towards are more of a universal rate that would be applicable across broad groups of customers. Concepts like class might not be as predominant. It'd be a time of use based rate, or not, yeah, a traditional time of use based rate, inclusive of some additional charges. I know reactive demand is one that we've talked about a little bit off and on today that might be applicable to those rates. But very much a deviation from where we are today, especially in our non-residential rate classes where we have distinct demand charges and energy charges. So there's quite a bit of difference between what has been presented as a rate modernization vision from staff to where we are.
Okay, and there were some questions about relationships between staff and company.
Yes.
Did staff file a complaint on our rate modernization issues discussions?
Yes, one of the items was included in that complaint case.
And has staff also filed the same complaint on this data retention case that we're doing right now?
Yes.
And in that complaint case, are they asking for essentially the same data they're asking for in this case?
Yes.
Let's go back to the big picture a little bit. Well, before we do that, the judge asked you about, could you go out to a third party and get some bids and find out if we couldn't get this done? Was there really any third-party vendor out there that could give you information on data request number 1 that would be helpful?
Again, relying on Sean Riley's testimony, I would say no.
Okay.
I mean, we did not approach the market with some kind of a proposal, request for proposals or something of that nature, but based on his testimony, I would agree with that.
I'd like to go back to your discussion with, I think it was staff counsel, about a preferred route forward and make sure we've got that in one spot in the record here. What do you see as the preferred outcome for this case now that you've been through it?
I think it's inevitable that there's some form of case to carry this effort forward. I don't know that this one, a continuation of this one, is the best solution, but some forum for us to continue to move forward. Guidance from the commission as far as how we should proceed on some of these matters, if there are any limits that we should consider, if there are any mechanisms that we can use to be held whole in the process. Those type of items would be helpful. I think that's a general structure.
So the commission should look at our data requests and decide whether we need to answer those, what the cost is, otherwise, how to go forward?
Right, because I believe, in my opinion, I think these have set out the overarching boundary or high-level ask, and based on guidance, we could refine that and maybe find an alternate approach that lives within that we can mutually agree on. But we need some guidance to get there.
I'd like for you to expand on why you don't think leaving this docket open for additional discovery is the right path.
Yeah, I mean, this docket, and depending on what can be done to change it, but the discovery rules that were set out in this, the accelerated turnaround time on discovery, for example, is problematic. We agreed to that to facilitate an overarching schedule, and that's been met with this hearing. So now as we go forward, there would need to be different terms for interaction on discovery and things of that matter.
Well, just on that point, I think you talked with staff about, they clarified that there are 2 companies here and a lot of their data requests were duplicative. You remember that?
I do.
Well, for that, would you agree, or I'd like to read for you a few areas where they asked for 10 years' worth of data for each of the companies and asked me if you recall that that's the way it was. Did staff ask for as much as 10 years' worth of data for gross plant, depreciation reserve, net plant, and depreciation expenses?
Yes, that sounds familiar.
For line transformers, land rights, structures, and improvements?
Your Honor, I'm objecting to this line of questioning. Staff didn't say anything about 10 years of data, and I don't know what request Mr. Fisher is referencing.
Well, I can give you the DR numbers if you'd like, but I'm following up on the questions that were asked from the bench and the staff council.
I don't think the bench asked anything about specific data requests, so unless they're the ones that staff has already entered in this case, I don't think they're appropriate on redirect.
The staff council opened this whole area up whenever she said, oh, we all have jobs to do, and she was talking about data requests.
Your Honor, that's a very slim thing on which to hang this argument.
I'm asking about the process that will go forward if we leave this open as a repository for data requests.
Mr. Fisher, you don't think Mr. Lutz's pre-filed testimony was sufficient?
No, Judge, he did not address this. He did suggest, I think, that he disagrees that he, in good faith, tried to answer those data requests. And I'm following up on that as well.
I'm unaware of where that reference came from.
I'm getting a little lost myself.
Well, okay, let me ask you this. Mr. Lutz, did you suggest, I think, to the commission that you felt that you had participated in good faith in this process?
Yes,
And that was in reference to the answering the 200 data requests that the staff proposed in this case?
I consider that part of that good faith, yes.
And you were requested to do it in 10 days?
Yes,
And the staff denied you when you requested an extension?
I believe so.
That didn't encourage more talk, did it?
Staff, I'm sorry, Your Honor, staff objects.
Okay, I'll withdraw that, I'm sorry.
I was gonna say, that was not something that was brought up. There's nothing on the record in regards to that.
Would you expect, if the commission leaves this docket open for a repository for discovery, that we would receive a lot of data requests like we received in this case?
I hope not, but I don't know.
Why would you hope not?
It's a lot of work.
We all have jobs to do besides answer data requests.
Well, I mean, yes, I mean, I acknowledge, I mean, their staff is just trying to find out how to get data. I mean, I understand what's trying to be accomplished, and maybe the key takeaway is that we've got to find a way to get there, to move to a middle point in some way. I think we've made a case that what is being asked has problems, and if there's a way for us to find a middle ground, maybe we can be more successful. But the way these 9 questions are phrased and constrain us, it's difficult for us to achieve.
If the docket is kept open for discovery, in your years around the commission, is it your understanding that in discovery, the company provides the data that it has, but it's not asked to create data or do analysis that does not exist?
Correct.
That's different than what's happening in this case, is that right?
Yes, yes.
Mr. Opitz, whenever he started a long time ago, 4 hours ago or so, talked to you about revenue requirements, cost allocation, and rate design. The cost allocation issue goes to data request number 1, principally, and 8, which asks for all that information upon request.
Yeah, yes.
Would you explain what cost allocation, what role that plays in a rate case, and do you need to have the most up-to-date information about cost allocation in order to process a rate case?
Okay. Yeah, the allocation is a mathematical exercise to distribute the jurisdictional cost across the classes. And in doing so, you're trying to align cost causation with the costs that are borne by those respective classes. Now, the purpose of that is to provide information about the relative rate of return, maybe the pricing that might be incurred for one of the elements or whatever. But the allocation process is aligned with your data from your test year. So everything in the rate case is built around the concept of the test year. So your allocations are aligned with that time period and based on the same data. And so it is common for that data to be historic. And I think we explored it with staff that it could be up to 18 months variant from the current date at that time. But that's in my experience, just the natural timing of a rate case. That's an 11-month process in this jurisdiction. So there's a certain aging of the data that's just built into the process. But the allocations, as long as they're aligned with the test year data, are perfectly acceptable in my opinion.
And that allocation process goes to how much of the increase should residentials get, small commercials, industrials.
Correct, at its most basic, yes.
And you've been around the commission a long time. Have you seen many cases where the commission has said, this class cost of service study is the right one, and we're going to adopt that, and we're going to set rates on that?
No, very few, if any, have I ever seen that.
A lot of times they look at all of them and decide what's reasonable, given all the evidence.
Right, or it's a settled matter.
And sometimes it gets across the board increase.
Correct.
And if you had a perfect cost of service study that took that DR number one and had all that data, and you had a better cost of service study than the previous one, it might not make a end result any different.
Possible, because the commission in its judgment could choose to accept or deny any parts of that in setting the rate.
Does the commission need the granular data that the staff's requesting in order to do a traditional rate case, even if it has time of use rates within it?
I would contend no.
You know, Judge, I think I'm done. Thank you very much.
Excellent. Thank you, Mr. Fisher. Mr. Lutz, you are excused, subject to recall. Dr. Mark, come on down. We are going to try and fit your testimony in before 5.
All of it?
Subject to recall. He'll be back tomorrow.
Okay.
Okay, raise your right hand. Thank you, sir. Do you solemnly swear or affirm that you will tell the whole truth during your testimony?
I do.
Thank you. Have a seat. Mr. Kleiser, your witness.
All right. Can you please state your name for the record?
It's Jeff, Geoff, Mark, Marke,
And by whom are you employed and in what capacity?
at the Missouri Office of Public Counsel. I'm the chief economist.
And did you prepare a cause to be prepared, pre-filed testimony for this case that has been marked as OPC Exhibit 300, the surrebuttal testimony of Jeff Mark?
Yes.
And do you have any corrections to make to that testimony?
No.
And if I were to ask you the same questions today that are in that testimony, would your answers today be the same or substantially similar?
Yes.
All right, now, Your Honor, I'm going to do this very slowly for the record. We originally filed this testimony as both public and confidential. The only piece of confidential information designated in the testimony appears on page 9, lines 14 to 15, and encompasses the costs for these investments, which not investments, the costs. My understanding of which has been that that is made public. I am therefore moving to offer the confidential version of Dr. Mark's testimony as the public version, and there would be no subsequent confidential version.
Because this is unusual, I would like to get an affirmative reaction. I would like to get a reaction from Evergy, either way.
It's going to be filed public, one version.
Thank you. Any objections to the admission of Exhibit 300? Only a public version. No objections, so admitted.
And Your Honor, as I had said in the past, or previously, if the commission would like, I can move to late file a copy of this that will strike the confidential designation. I can see that you are saying no. Okay. In that
Yeah.
case, I tender the witness.
The judge will either work on it or have some staff remove the words confidential and stuff. So we'll take care of it. We're on cross-examination. That starts with staff. Ms. Kerr.
Thank you. I just have a few questions. Is it reasonable to do a deep dive in distribution in every rate case, or to look at it every few decades or so?
That's a good question. Well, we haven't done a deep dive in 4 decades, right? Well, 3 decades. It's the 90s since we are reflectively relying on that information from that last distribution study. So, I mean, that's why we're here. There's a lot of pushback that, this is stale data, this is old. I think what's lost in this conversation is that there's been huge amounts of investment that have moved forward. I've heard testimony, well, no other state's doing this. No other states as far as Missouri is in time of use rates. I can think of very few utilities that have had AMI investment for more than a decade. I mean, it hasn't been fully deployed, and I'll acknowledge that, but it's a knee-jerk reaction to kind of compare utilities or states here, and I just want to put it on equal ground here. But yeah, I would say it's very unusual to rely on information that is that old in light of all of the investment that we've made moving forward.
So you would say that you need to
You need to update.
update.
Yeah. I would agree with that.
Can you study peak response to the to time-based price signals without hourly loads per time-based rate code?
No.
And why not? Can you explain that?
Can you study it? I mean, without the information to support the rate design that's being applied to it, I think it would be a challenge.
Okay, so you need that data.
Yes.
And in your testimony, you talk a lot about information asymmetry. Can you explain what the problems of information asymmetry are if staff or commission can't get the information that Evergy committed to provide?
Well, you're not realizing the benefits of your investments. I mean, that's really what we're talking about here. My testimony spoke about information asymmetry, and I think the testimony explicitly said it doesn't necessarily need to be a bad thing. I mean, it's going to be inherent in just about any business practice. It's more so on a natural monopoly with a regulated sector. I mean, that's why we have regulation, is to break down that information asymmetry as much as possible, to align cost with cost causation. The inherent problem with it is it's time. It's an opportunity cost that's associated with this. I think my testimony was like 472 days. I think 495 days as today when the commission issued their order to today. And what did we get to today? Oh, we can do some of this stuff. But it took us to go ahead and have a hearing. It took us to go ahead and file testimony. It took us to go ahead and flesh this out to minimize that information asymmetry. Otherwise, it's cryptic DR responses. And I'll give all the props to Mr. Lutz. He's very articulate, and quite frankly, he's been a pleasure to work with over the years. That being said, that's a lot of time to pass between A and B to where we are today. So there is a level of frustration with not being able to have the information that you need to provide the best information that you need for the commission to make their decisions, quite frankly. The analogy that I would make is, and Mr. Stallman's going to get up here and maybe he'll talk about weather normalization here in a second. For years, we never did weather normalization. You look back at go back to those commissions, nobody knew what weather normalization was. But at some point, the commission said, yeah, that's a good idea. I'll take it a step further for that history context. They went out and hired independent economists, some of the best, and were employed by the Missouri Public Service Commission staff to go ahead and implement that, and worked with the utilities. And it was a cost. I mean, there was a cost associated with that. It was a big push. But now it's just accepted. You can't do it without weather normalizing data. Well, technically speaking, we did for a number of years without having that information. We're at the same sort of breaking point today. We have more information than we did before. So Mr. Lutz is right. I mean, we can sit there and we can set rates without it. I would also say they're wrong, or at least incomplete, because as he said, this data exists, all the data's there, it's the deliverable action to it. So that's the frustration with this, and in full fairness, I've got the same sort of frustration with staff on this because it sounds like the response is, well, let's keep open this docket and let's keep talking about it. My testimony spoke to that and said, well, that's where we are at today. I don't have much assurance that that's going to maintain moving forward. So I'm going off question. I do that. I'm sorry. Go ahead.
It's all right. So your counsel asked Mr. Lutz about waiting until after an order in a rate case to study customer impact of a proposed rate design. What sequence would you prefer?
I've given this a lot of thought, like just today. What I would prefer, it sounds like the parties are moving towards whether it's this docket or another docket. I would agree with Mr. Fisher when he talks about leaning up, The issue, I think, for Mr. Lutz is, right now in this docket, you've got a discovery process that's really expedited, and it's because of this hearing. So yeah, ease up the discovery process, open up a dialogue. I'll keep my fingers crossed and hope that we can reach more cost-effective solutions moving forward. That being said, if I were recommending, well, my recommendation to the commission would be, if you go down that route, then have some fallback, or you're going to end up in this exact same situation. And that fallback would be, do a distribution study. Absent that, just go out and do the study. Update that 1990 study. It's not going to encompass everything that Ms. Lang wants, but that's where the commission can empower other stakeholders to say, hey, we can provide input into the formation of that study. We can go ahead and emphasize that stuff like continuing property records are pretty darn important. We need to know exactly what's out there. Or otherwise, quite frankly, and I've had this experience with other utilities, I can't speak for Evergy specifically, because again, it's been since 1990 since we've done this. But for other utilities, yeah, it's eye-opening to see, wow, we've got stuff on the books from the 20s, the 30s. That shouldn't be there. Can you identify this? Nope, can't do it. Tossing it out. But that's the sort of frustration that we're at. That's that information asymmetry. So everything that Mr. Lutz is saying, that Evergy, hey, we've always done rates this way, you're right, and we can continue doing this. We can continue doing things like we did back in 1910 if we wanted to. And technically that would fall under that formation, but that's ignoring the huge hundreds of millions of dollars of investment that we've made to go ahead and for lack of a better word, at least it was implied that we would have this information with this investment. We would make the AMI, we'd make the CIS information, and then we could go ahead and move forward with a lot of stuff. The commission, to their credit, how many dockets have we opened up over the years? Just workshop dockets to go ahead and open up DERS with net metering, with cogen, with rate design. All of that stuff is interdependent. So if the commission values that, if the commission wants to move forward with that, then I wouldn't just dismiss this out of hand. It's tied to it. So, yeah, all right.
Thank you.
You need like a bell.
So sitting here today, do you have a clear understanding of Evergy's bright line proposals?
No. I don't have a clear understanding of what Evergy's costs are associated with this. I've heard top down, bottom up. It's all intermingled. I don't know. Again, I look back and we had 500 days to go ahead and figure out some sort of more concrete cost. It's unfortunate that we're here at this point.
Do you have a clearish understanding of staff's rate monetization laid out in their DER case?
Oh, yeah. Yeah. The EW, I think it's 2017 case, I don't have the number in front of me. So the commission opened up a DER docket, and there were a number of things. It's a huge docket. It was spread out over a couple years. We had several different workshops. One was just on demand response. We did stuff on just, we did a hosting capacity analysis. We brought in, let me step back. I didn't do anything about this. This was, the commission brought in outside experts. We had the state that is moving forward with the hosting capacity analysis right now, Minnesota. So you're talking about states that have done this? There you go. Minnesota's doing this. All right, they're moving forward with this information. I mean, in part, it's tied to the investments that they made with AMI, but also moving forward with the hosting capacity analysis. You've seen, so the commission moved forward. They posed questions, and I think one of the questions was explicitly, what role does the commission have in promoting a rate design? Everybody had an opportunity to respond to it. We responded to it. The company responded to it. And the company's response was see what we replied to in the last rate case. But everybody had an opportunity to respond to it. And when we went back and reviewed that docket, I mean, the commission, and this came up in Mr. Kleiser's opening, the commission supported their staff. They said this was good public policy and to move forward with it. And again, I mean, that's what effectively we as a collective group did. We've been having these discussions. We've been having these rate cases, and things get punted down the line. So yeah, I'm very familiar with staff's position. I don't always agree with it. I can tell you I'm not frankly thrilled about the idea of introducing a demand charge to the residential customers. I understand it theoretically and why unbundled rates makes a lot of sense. I've got a tougher time, especially in light with how time of use played out, like how the public might accept it. But long term, I mean, to bury our heads and pretend like this isn't going to advance, I think is naive. Another workshop that had been opened up, FERC 2222, leads right into exactly what we're talking about here. So I think it's important. It was important enough for us. We weren't heavily involved in this case until towards the end we realized it was actually going to hearing, that things had kind of stalled out. And that's where we threw in with surrebuttal. But this is, that forced us to really examine staff's position and frankly to support it at the end of the day.
Thank you. Is it your understanding that information about distribution costs by voltage is only needed for rate modernization, or is it needed for a study of Evergy's current tariff rate, or current tariff sheets in rate cases?
I mean, it's definitely not only. And I go back to the comment before. We can, having that information would better align cost causation. Absent that, you are necessarily, people are going to be subsidizing one party or another more than not. You know, I think it's curious, now we're seeing like commercial industrial customers come in and say, oh, we don't want to do this. Well, I mean, a lot of that has to do with the methodology that is being utilized today. And that methodology is based on a world that doesn't exist anymore. That Naruc study was produced in the early 80s, before the SPP integrated market, before the AMI investments, before all of this that we're trying to incorporate. So I am all in favor of moving forward if we've spent the money on these investments, and we have spent the money on so much of these investments.
And so does Evergy charge customers today differently based on the voltage at which they're served?
Yes.
The voltage at which they're served? Okay. Now, finally, Evergy gave staff a large range of costs and didn't break down the cost for that first item one in the stipulation. And I know OPC asked DRs of Evergy for the breakdown of the cost estimate, and what you received, was that very helpful?
No, I don't feel any better about what the necessary costs are for any one of these things.
Would a breakdown have been more helpful, or is there an alternative way for Evergy to have provided the cost than just a range?
I mean, the only, quite frankly, the only cost that I feel like I've got a good handle on right now is their consultant.
Okay, thank you. I don't have any other questions.
Thank you. Mr. Opitz.
No, thank you, Your Honor.
Evergy.
It's almost 5 o'clock. Thank you. No questions.
Are there any questions from the commissioners? Chairman Root.
Thank you, Judge. Thank you, Dr. Mark. So you threw out the idea, let's go ahead and just do a new distribution study. What would the cost for that compare to what staff is asking for, in your opinion?
It's a great question. So there are a lot of things encompassing what we're talking about here. You know, we've talked about two different buckets of stuff. It sounds as though that everything that's related to customer accounts is something that the company feels like they can get moving forward. So I'm not including that in this calculation. When I talk about the distribution study itself, what I would recommend is, before we jump to that conclusion, I mean, perhaps people can work together. We can move forward with this. You've heard a lot of esprit de corps, right, and what we're doing. Maybe that works. Maybe this is enough of a pinnacle to move that needle. I've got some reservations in whether or not it's going to be applicable for their upcoming rate case. But if that's a path forward, maybe we don't need to do a distribution study. Absent that, from my vantage point, when I hear, wow, like it's been a while since we've actually looked at some of this stuff, where we've actually done the continuing property records, where we've done the distribution study, then maybe it's time we update it. Now, the cost associated with that, we can provide that in a, well, I don't know if we can. We've got experience with that with Spire right now, and it's going through the RFP process. So I don't believe a vendor's been, and I'm not even sure I can disclose that in this context, but it's a lot less than 100 million, I'll tell you that.
We've also heard testimony from two different witnesses or attorneys or people that made reference that the other large electric utilities, Liberty and Ameren, are much farther along the road of providing data to staff. Can you expand on that, and what is your vantage point from the Office of OPC? Can you validate that?
It's different cultures. I mean, just really get down to it. It's different cultures, it's different utilities, and sometimes those relationships ebb and flow. And right now, we are having a rough time. I can say there's the big distinctive difference between Evergy, and why Evergy, I think, is at the forefront of what we're discussing here, is that they are so much farther along with having AMI deployment. They've made the investments. Heck, the last rate case, they tried to make an additional investments on the AMI. So Ameren's not even fully deployed at this point. I mean, the easy answer to it is like everybody in this building is overworked and has way too many fires to effectively put out at this point. If there's movement in this docket, you're going to see movement in others. But I can say that the dialogue has been at least productive. I hope I'm answering the question, Chairman. So, you know, there are different stages with where Ameren and Empire is versus where Evergy is. It's going to be more of an issue, I'll put it that way, given the different codes that we have, especially within the context of residential at this point.
So taking a step back and getting away from this case and the specific requests that staff has wanted, would that difference of cultures of which you just spoke, does that extend to all data requests from the company compared to other companies? Is there a marked difference between how Evergy handles data requests in general to OPC and staff, in your opinion, than the other utilities?
Unfortunately, yes. And look no farther than we get routinely, it's almost by default, we'll get DR responses that we object to this, but we'll give you the information, we'll go through this, and it's just an additional hurdle. That element I don't see as present with other utilities. And I'm not saying that the company doesn't provide the information that I seek. They do. But there's a caustic attitude with that I don't think is helping the dialogue, or at least helping the relationship right now. That being said, full disclosure, the company has been forthright with, especially within the past few months of opening up a dialogue with OPC and trying to mend some fences, and we support that. Contrary to popular belief, we want a healthy utility. It doesn't serve anybody. I say healthy, all right, but you know, but it's true. I mean, the worst thing that we could do is, well, there's a lot of worse things, but yes.
I'm not going to ask the court reporter to read that back, but I just wanted to make sure I got your quote right, so when I tweet it out that Dr. Mark says OPC wants to help the utilities, that you'd be comfortable with that, so. Thank you, Doctor, appreciate it.
Thank you.
Any other commissioner questions? We are at a minute or so after 5. We have finished the commissioner questions. We would now go to recross and then redirect. Does anybody think that their recross or redirect will last more than a couple minutes? That's cool if it does. Awesome. Let's go ahead and move forward then. Who's got recross first? Staff.
I just had one question I wanted to clarify. Something Chairman Roop had said, if is Spire doing a distribution study or updating the continuing property record?
Continuing property record,
Okay.
yes.
Okay, I just wanted to clarify
You're right.
that.
But I think that we go in, it's a different type of, it's a gas utility, it's electric utility, there's different, but yeah, it's a continuing property record. That would help shed light effectively on what we're trying to do here.
Okay. Okay, that's the only question I had.
Ms. Tropitz.
I guess I'll follow up on your response to Chairman Roop. Doing the continuing property record doesn't solve for the issue of allocating those costs as staff is asking to do among rate codes or, I guess, theoretically even rate classes. Is that correct?
Can you say that again?
If the company were to do a update to a continuing property record or, something similar to what Spire might be doing, that doesn't solve for the issue of allocating those costs among the rate codes as staff is asking the company to do.
Not
Is that right?
entirely.
Thank you.
And Evergy.
No, thanks, Judge.
And redirect.
Aware of the time, I will try and keep this as brief as possible. Really quick, you were asked a question by staff with counsel about the information asymmetry, and your response basically referenced the idea that time is the principal problem. Do you recall that?
Yes.
Are you aware of whether or not the company is expected to file a rate case here shortly?
Sorry.
How do you expect that this issue is going to be played out in that rate case, given the information asymmetry you were asked about?
If I'm a betting man, I'm going to probably read testimony very similar. I think Ms. Lange could probably copy and paste her testimony from the last rate case.
Very well. And at the risk of confusing this, is it a choice between a distribution study and a continuing property record audit, or are they two different things you want to do? Or
I would say that they, together, both of them is really what you want.
okay. I don't think I have any other questions. Thank you.
Thank you, Dr. Mark. You are excused from the witness stand, subject to recall.
Thank you. I'll be
Let's
here.
finish up for the day. Commissioners, we are done. I'm going to make a couple announcements. Before anybody leaves, let's talk about 9 a.m. tomorrow. Does anybody have any strong feelings about moving our start time to 9 in light of we're halfway through? We have the commissioners who have very graciously moved their agenda meeting until noon. Excellent. Without objection, we will move to 9 a.m. tomorrow. Any other business to talk about?
Your Honor, I have one issue. I would ask that MECG be excused from appearing tomorrow. I will waive cross on any witnesses who appear and accept the record as it's filed after the hearing tomorrow.
Any input on MECG's request? Granted. Excellent. We are adjourned.